The Honorable, the judges of the United States Court of Appeals of the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, I'll call the first case this morning, United States versus Jackson, and Mr. Childers. Whenever you're ready, we'll hear from
you. Good morning, may it please the court. Andrew Childers on behalf of appellant Richard Jackson. We're here today on the appeal of the denial of Mr. Jackson's successful.
We're across the room, so you want to speak as you're talking to the back of the class.
Yes, sir.
Okay.
All right, excuse me.
Yeah.
We're here today on the appeal of the denial of Mr. Jackson's successive 2255 motion. And this case really boils down to two questions. And those two questions are whether federal first-degree murder under 18 U.S.C. section 1111A qualifies as a crime of violence under the force clause, and the same question for the aggravated sexual abuse statute in federal law. And neither of these statutes qualify under the limited definition of the force clause. And that's because neither requires the use of force against the person or property of another as an element of the crime. And that's because both statutes are written broadly to encompass a wide array of conduct that the federal government is interested in punishing. And the force clause only covers a narrow class of crimes. Murder is not a crime of violence because first-degree murder encompasses felony murder. And as we know from the recent United States Supreme Court decision in Borden v. United States, a crime of violence requires a mens rea greater than recklessness, and felony murder can be committed even accidentally. And the fact that felony murder can be committed accidentally means that it does not require the level of mens rea required of a crime of violence under the force clause.
That Borden case, is that what you think saved you?
The Borden case, I think the Borden case is directly on point here. I think even before the Borden case, for the Fourth Circuit, this court's precedent was aligned with Borden and recognized that a mens rea there had to be a heightened mens rea.
I thought the court in Borden said murder was the quintessential crime of violence.
There is dicta in Borden that says
said it. I mean, it's not the holding of Borden. The holding of Borden focuses on recklessness, but distinct from that discussion of recklessness, it made a comment that murder was a quintessential crime of violence.
And I think that's right in the sense that we normally understand murder. We have to look at the specific murder statute at issue in this case.
But it could be committed in different ways. That when we get to look at the different ways.
Well, I think
this divisible.
Again, yes, the government does not argue that felony murder is a crime of violence. The government argues that the statute is divisible.
Well, why don't you address that argument?
Of course. So the statute is not divisible. It's an indivisible statute of first-degree murder because ever since the common law, felony murder has been understood to be one way of supplying the heightened mens rea necessary for murder. And the common law was incorporated into the federal first-degree murder, the federal murder statute, along with several other states. And the United States Supreme Court discussed this in Shad v. Arizona. And Shad v. Arizona is the closest case we have. It's not directly on point. It doesn't address the divisibility of the federal murder statute, but it addresses a very similar statute. And what it says is that these murder statutes in the majority of states and the federal murder statute were written to incorporate the common law. And the common law understanding and the understanding of the law in 11 out of 12 of the 12 state statutes discussed in Shad is that felony murder is a means of committing first-degree murder.
Yeah,
it's
but
a way.
if you were talking to a jury, instructing a jury about what to find under felony murder, you would not need to say that the killing was premeditated. You would only need to say that the killing was committed in perpetration of arson or escape. But if you were instructing the jury on the first thing, you would have to say the person premeditated, it was a premeditated killing, which is a different element. And so the elements are clearly, the first line is perpetrated by A, B, C, and D, and willful, deliberate, malicious, and premeditated killing. So the premeditated aspect is necessary for that definition of murder, but it is not necessary for the felony murder.
Yes.
So wouldn't we divide it then into two, because it has different elements, divide it into two crimes?
Well, I think the key distinction is whether a jury is required to find what I would describe what you just.
But here the jury did find, it was given alternatives. And it found all of them against your client.
That's true. But initially, actually, the way the jury was instructed in this case is
they did a good job with that jury verdict form, looked to me like.
Illustrative of Judge Niemeyer's question, in that the jury was initially, for the 924C general verdict finding, was the elements of felony, was instructed on both felony murder and premeditated murder. And it was not required to make a unanimous finding on one way or the other. And that's the key issue here. Sure, a jury can be instructed on different means of finding a certain element. But for federal first-degree murder, there is a heightened mens rea element that takes the murder from general, second-degree murder into a heightened category of first-degree murder with an additional mens rea element. And Shad makes clear that that additional element is all the ways of committing first-degree murder listed in the statute. A jury does not have.
The question that I thought we were asking you to address is whether it's divisible. And one way to look at whether it's divisible is whether the different components have different elements as opposed to different means. And I was just asking you the question of, when I'm now looking at 1111A, the first component requires premeditation. The second component does not, but it requires something else, the perpetuation of arson or escape or whatever the crimes are listed. So the first one doesn't require showing of a perpetration of arson, so the elements are different. And it seems to me that would be one of the ways to determine whether to divide a statute, isn't it?
Well, so the key distinction between elements and means is what has to be found beyond a reasonable doubt unanimously by a jury. And those are different.
Well, that sort of begs the question. If it is a different element, then you're going to have, each element has to be found by a jury. But the question is to look at the statute and determine whether there are different elements for the different components.
Would
you agree those are elements?
No, I believe they're different means of committing the heightened, of supplying the heightened mens rea necessary.
Do you agree that that's the biggest issue in this case?
Yes, I do agree with that.
Whether this statute is divisible or not.
Yes, that's right. I do believe that the biggest issue in this case is whether the first degree murder statute is divisible or not.
Okay, and so explain to us now why it isn't divisible.
It's not divisible because in Shad, the Supreme Court said a very similar, almost identical first degree murder statute said that it was okay for a jury to convict of first degree murder without unanimously agreeing on a felony murder means or a premeditated murder means.
They did agree.
In Shad?
Here they did agree. We know that. Whether we can look at it or not, but we know that because that's what the verdict was.
Well, that's true.
They agreed on the verdict unanimously, and they agreed in the verdict as to each of these subparts unanimously. That's what the verdict says.
That's true, but we're not talking about what the jury unanimously. We're talking about whether the statute is indivisible or divisible for
you got it, but that's right, and that's what Judge Mott asked you. But you said they weren't required to agree, and they were required to agree, and they did agree unanimously that this was a premeditated murder. The question is whether we can look at it under the law. That is whether it's divisible or not.
can only take a peek at the.
No question that they found that it's a premeditated murder, and they found it unanimously.
That's no question, but you can only take a look at the verdict forms in this case for the limited.
That's what you have to convince us of, that we can't look at that verdict form.
No, and that's right, and you can't look at that verdict form because you can only look at it for the determination of whether the statute in general is divisible or indivisible, and to make that determination. And once you make that determination, then you go back to the categorical approach and analyze this case under whatever decision you make with regards to whether it's divisible or indivisible. And I would say,
I heard those words, but I didn't understand how that related to this case. In other words, what do you propose that we are supposed to be doing if we're trying to decide whether this statute is divisible and whether it was properly applied in this case, or under a divisible statute, the jury properly found first-degree murder?
the first thing you look at to determine if a statute is divisible or indivisible is the text of the statute. And the
Right.
next thing is the decisional law. And I think Shad makes clear that this kind of first-degree murder statute is indivisible, because this kind of first-degree murder statute lists means and ways of committing first-degree murder rather than separate elements. And the Supreme Court said as much in Shad. The Supreme Court cited Shad in Mathis when it was discussing what are means. Just yesterday, this court cited Shad for the concept of this distinction between means and elements of a crime.
And this ACCA case opinion came out yesterday.
Yes, that's right.
The Wooden case. And you think that helps you?
Well, I think it cited Justice Scalia's concurrence in Shad that, and he said it's long been recognized that even when there are different ways or means of committing a single crime, the jury does not have to agree on the way the crime was committed. It just has to agree that the crime was committed.
But that sort of begs the question. We know if it's different means. The Supreme Court said that you can commit a single crime by different means. But when there's different elements for commission of crimes, that they've said that makes it divisible. And if you charged, in this case, if you charged a defendant with killing someone while attempting to commit arson, that would be a felony murder charge. You wouldn't need to show premeditation. You would have to show an attempt to commit arson, and you'd have to show a killing. But if the government charged the defendant with premeditated killing with malice aforethought, they wouldn't allege the arson, and they would have to allege premeditation, which are different elements to be proved by the government.
In response to that, I think the hypothetical, which actually
I'm trying
happened
to focus on the statute. It's right.
Yes.
I just really restated the statute. And
well, it's also possible to charge a defendant generally with a violation of murder, first-degree murder under the statute, and to instruct a jury on both felony murder and premeditated murder.
The charge just cites the statute. You'd charge them with all three of the alternatives, and you would instruct the jury, and you would give them the verdict form with the interrogatory as to each of the three alternative elements, sub-elements, or whatever you want to call them, or means. You're saying they're means. That's what you need to say. But then the jury could say no on premeditation and yes on felony murder, or yes on aggravated sexual assault, or no, whatever. But here they said yes as to all of them, each of them, not just generally all of them, but each of them, on the verdict form. They said each. And so the jury found unanimously he committed a premeditated murder. And the facts are, it's a terrible, terrible situation. It gives rise to all this.
Yes, Your Honor, but we know the facts are irrelevant in this categorical approach.
But they're here. I mean,
I would also just
they're in this record
that the findings
these cases have been here before.
Yes, Your Honor. But the findings that you keep mentioning are the special verdict form, the second sheet of the verdict forms. The first verdict sheet, the general verdict sheet, follows the indictment in this case. The indictment in this case charged Mr. Jackson only with murder generally. It did not select.
That charges him with all three. And that charges him with all three parts.
But in this case,
you charge basically in the conjunctive, you give him notice, but then you instruct in the alternative and ask the jury specifics. And they made a perfect jury for him here, I think. And they asked him each question, and the jury answered them all against your client.
The Supreme Court has said in discomps that generally, if a statute lists elements, a prosecutor has to choose which one of the elements it is charging under. Here,
they charged under all of them.
They
charged under all of them, and the jury found under all of them.
They charged under first degree murder generally. They charged under the murder statute generally. And if you look at the instructions on page 1244 and 1246 to 47, when, we have two findings in this case. We have a 924C finding and a 924J finding. And for the 924C finding, the jury was instructed the way the instructions read in this case. They did not have to agree unanimously on felony murder or premeditated murder. They were instructed on both. And the element of murder, the judge said that you have to find that it was either premeditated or committed in the course of a felony. And then the finding related to those instructions are on that first page, the general verdict form in this case. And it's a general finding, not of any specific kind of first degree murder. It's a finding of first degree murder generally.
And so they found specifically that as to each of them, and they said yes.
It is true that the jury was
absolutely specifically, and they found that entire verdict unanimous.
And that's related to the 924J instructions, the finding, because to be convicted of 924J, it has to be a death occurring during the commission of a 924C.
But all that comes down, you have to convince us those are alternative means rather than alternative elements.
That's right. That's right. That's
alternative
exactly
elements you lose. And for alternative means, you may be entitled to something.
If they're alternative means, we certainly win. If they're alternative elements, it's more difficult for us to win, but we still win because the Shepard documents have to speak plainly and establish with certainty, as the Supreme Court has said in Mathis, all the way back to Taylor. It has to be absolutely clear from the Shepard documents that the statute is divisible. And it is not clear in this case because we have a general verdict finding. And a hypothetical I would offer up to the court is, what if the second page of verdict forms wasn't in this case? What if we just had the general verdict form with no specific finding?
Then you'd have a better argument.
Well, of course we'd have a better argument, but I would offer, would that be unconstitutional? Because
but we've got to play what the cards are.
Yes, but we can only look at
a verdict form that says what it said.
Excuse me.
So what if we didn't have the page that you're relying on?
If we didn't have the page, if we had specific findings?
We have exactly what we do have on the second page, the thing that we are relying on, where there seems to be a unanimous jury verdict on all three.
I see my time is up. May I answer the question?
Yes, I think you can.
I think then when we have what we have, it's unclear whether or not the statute is divisible or not, because there are indications in the indictment and in the instructions that the statute is indivisible. And granted, there are the special verdict forms that cut the other way, but we cannot say with certainty that the statute is divisible. So this court must treat it as if it is indivisible. Thank you.
Can I, before you sit down, ask you one question? What is a killing with malice aforethought?
A killing with malice aforethought is anything from intentional killing down to a killing with reckless disregard for the value of human life, and also a felony murder.
On that aspect would be malice includes recklessness.
Yes, but I think the pending case in Manley would answer any of those, speak to any of those arguments regarding malice aforethought.
What would do? I'm sorry, didn't understand what your answer was.
There's a pending case, Manley, that deals with whether recklessness suffices, the recklessness under.
What does it say?
It hasn't been decided yet. It's before this court.
All right, thank you. We'll hear from Enright. Thank you. I'm sorry.
Good morning, Your Honor. May it please the court. Anthony Enright for the United States. The district court properly denied Richard Jackson's 2255 motion, concluding that murder and aggravated sexual abuse qualify as crimes of violence under 924C.
Can you pick up on where your colleague left off? It seemed to me he was saying that recklessness could satisfy the element necessary for first-degree murder. Is that correct?
No, Your Honor. First-degree murder, murder with malice of forethought only is second-degree murder. And I don't think there's any dispute here that the predicate offense was first-degree murder. First-degree murder is malice of forethought and an unlawful killing plus either premeditation and deliberation.
Premeditation or
premeditation and deliberation, or one of the specified felonies. The killing occurred in furtherance of one of the specified felonies in the statute. And
well, it has the statute incorporates the typical premeditated killing, which is understood most commonly as first-degree murder.
absolutely.
And it also includes the felony murder
Exactly.
concept, which is the killing in connection with another felony.
Exactly, Your Honor. And that the fact that the statute incorporates both does not disqualify first-degree premeditated murder as a crime of violence. This court held as much in Mathis. And even if this court goes beyond Mathis, the statute is divisible because premeditation is an alternative, not only an alternative, but an alternative element to the felony murder rule. And to determine that, you look at the indicia of divisibility that this court has developed over, and the Supreme Court have developed, summarized pretty thoroughly in its decision in Allred. I think we identified 7 in our brief. 3 that I think are the most significant are, first, that federal courts consistently treat them as distinct elements. This court, the Supreme Court, have both described them as elements, and the Supreme Court made clear that when a court uses the term element, what it means and what it says are the same. More importantly, this court has upheld, as have other courts, multiple convictions for multiple counts based on a single homicide. In Higgs, for example, there were 3 killings, and the defendant, this court upheld 6 capital sentences, 3 for murder and furtherance of a kidnapping, and 3 for premeditated killing. That wouldn't be possible if those alternatives were not elements. That would violate Rutledge, that would violate Blockberg, because it's the same transaction. So each one must have a separate element for that to give rise to separate convictions. So that means federal courts treat them consistently as separate elements. The decision the defense relies on, Shad, was the Supreme Court, but they were not interpreting the federal murder statute. They weren't even interpreting the Arizona statute. The Arizona Supreme Court had decided that, well, it's fine if 6 jurors agree that it's premeditation and 6 jurors agree that it's murder and furtherance of a felony. The Supreme Court had clearly done that, and what the U.S. Supreme Court said was, well, that's a constitutional choice that the Arizona court made. It doesn't say anything about the federal statute. If anything, it says the opposite, because that court undertook to tally the jurisdictions that had made a similar choice, and it identified 11. And conspicuously absent from that list is federal murder under 1111.
So you read Shad as relying on the peculiarity of state law there.
Yes, and I think Justice Souter's opinion, which is a plurality, says that explicitly. That we don't have to decide that. That is the choice the Arizona courts made. It may be a constitutional choice, but it's not the only choice. And there's nothing, against a background of years of treating them as separate offenses, there's nothing we have identified, and I can tell the defense has searched far and wide. There's nothing similar in federal law. I've not seen a decision. I've not seen a model jury instruction. I've not seen anything suggesting that you can prosecute somebody for felony murder or for murder under 1111 and have 6 jurors find premeditation and 6 jurors find an enumerated felony. I mean, it's difficult enough because you have to find the elements of one of the enumerated felonies. I mean, so, and that the jury instructions are that way too. That's one of the all-red factors. Jury instructions, some of them explicitly say these are the elements. Premeditation is an element and specifically refer to felony murder as a set of alternative elements. Some of them just give you one set in one chapter and another set in another chapter. None of the model jury instructions that I am aware of allow, even permit a jury to issue a split verdict like that, or to find first-degree murder based on a split verdict.
Did you all raise this divisibility issue in the district court?
We didn't, Your Honor, specifically say that it was divisible. We relied on this court's decision in Mathis.
You agree that's the most important issue we have to deal with?
I think so, Your Honor.
Controlling issue.
There are certainly plenty of other defenses we have to this conviction if this court disagrees, but I think that's...
Have you all waived it by not raising it in the district court?
No, Your Honor. This court can affirm on any ground fairly.
You didn't bring it up until you briefed the appeal.
We didn't bring it up until we briefed the appeal that it was divisible. And that's really an alternative argument, Your Honor, because this court has held specifically in Irby and in Mathis that murder categorically qualifies as a crime of violence.
I know, but that was when, that was before the Supreme Court had come out with its decision in Borden talking about what the intent must be. And so I don't think you can rely on those cases anymore.
Well, the reason, Your Honor,
as a general blessing.
So certainly, Your Honor, that's this court's decision. But the reason I would respectfully disagree is because Borden specifically says, you have to do, it follows the same paradigm as Irby. It says, look, we have to remember we're interpreting the meaning of crime of violence. And the rules are intended to distinguish between core violent crimes like murder. It specifically identified that as a core violent crime that's at the center of the term crime of violence, and those lesser offenses. So I think Borden is right on point with Irby, and indeed it specifically endorses the idea of murder continuing to qualify. And I don't think
in Borden the Supreme Court said that crimes that can be committed with a mens rea of recklessness do not qualify as violent felonies.
That's true, Your Honor. And
so it seems to me that it's hard to rely then on Irby, et cetera, that didn't incorporate that ruling from the Supreme Court in their analysis.
That's fair, Your Honor. And I mean, it may be asking a lot, but I think this court and the Supreme Court have both treated murder as a special case.
They have.
They have.
That was before Borden.
Well, I think Borden does too.
You're saying that then murder is an exception to Borden.
Well, it's one recognized by Borden because Borden says murder is a crime of violence. In its same analysis, talking about recklessness. And frankly, I just don't think the Supreme Court forgot.
He says that's dicta. That's what you're talking about.
I think it probably is dicta, Your Honor. It is part of the rationale for the court's discussion, but it also, I don't think the Supreme Court, 8 justices agreed with this point because the dissent agreed too. I don't think
agree with what point?
That murder is a crime of violence.
Well, it may be, but it can't be. Do you think that that there are 8 justices agreed that murder is a crime of violence, but that you don't have to do anything but say murder and you can have any mens rea? No.
No, I don't think they considered that point, Your Honor.
They didn't. Well, they considered the point that you couldn't use recklessness. That's the whole. That's why they took the case in Borden.
Certainly, Your Honor, and that's true. And the reason, Your Honor,
I'm not even sure why you're here. I would think you would be talking to us about. I guess you have to answer Judge King's question why you didn't bring up the whether this statute is divisible.
Well, I do want to answer that with your point, Your Honor. We addressed the appeal after Borden.
Okay, that's fair. The board may have changed your view of what is categorical, what had earlier been said is categorically a crime of violence, no matter what the mens rea was.
It certainly gave us reason to discuss the issue further and in more detail.
That's how the district judge ruled in that way, I think, in this case.
The district judge ruled that they categorically qualify.
Yeah.
Which
Yes,
is
you're
consistent with our prior law,
Consistent with our prior authority,
Yes, Your Honor.
which has been
placed in doubt
impacted.
by our board.
Certainly. It certainly requires a closer look. I understand.
It requires a close look at the mens rea.
Right.
Yes, Your Honor. And I don't think there's any dispute that the constituent parts of first degree murder meet that mens rea requirement. Premeditation is there.
You know, first degree murder includes felony murder.
It goes back to whether this
And
is
it goes back
divisible
to
or not.
this.
Premeditation murder. That's what I mean. Premeditation murder. I do think it's
But that's
divisible.
why maybe you should talk about whether it's divisible or not.
Certainly, Your
Because
Honor.
we've just decided that Borden would at least impact some of the possible divisions.
Certainly. I think the strongest points on that are that federal courts treat them as alternative elements consistently. Prosecutors charge them as different offenses. I think Your Honors accepted a representation from us in Allred. I also gave you a large stack of decisions in our brief where we've done that. You pick either premeditation or felony murder, unless the exception to that is if you want to charge both and secure convictions on both. They're
How
not
is it
treated as
charged here?
alternatives. What's that?
How is it charged here?
It was premeditation was explicitly charged, and felony murder was explicitly charged.
Separately.
Well, these were a single predicate or a group of predicates for a single
Your
924C.
indictment in retrospect could have been proved upon.
I'm sorry, I didn't hear that
I said
question.
your indictment in retrospect probably could have been improved upon,
Oh, yes, in many ways.
but your verdict form was pretty good.
Verdict form is pretty clear. It explicitly says, I do want to read it because I think
Did you
there's
try the case?
Oh, no, Your Honor. This
Whoever-
was,
Did a good job with that verdict form, I think.
I think they did, Your Honor. And I got to say, I don't think anybody anticipated that murder would be whether it was a crime of violence would be debatable. I do want to focus on that verdict form because there are a few things I disagree with my friend about. First, I'll read it because I think this is important. It says the defendant, Richard Allen Jackson, committed the murder of Karen Stiles with malice aforethought, willfully, deliberately, maliciously, and with premeditation. I think that's about as clear as can be that the jury unanimously found premeditation. But I think the defense has the standard a bit wrong. This court held on just a couple of weeks ago in Reed and also in Ali, which is a decision we cited. But the standard, if you have a question about which predicate the jury relied on in a 924C prosecution, the uncertainty about that wouldn't be enough. On a 2255, the defense has to show substantial or an injurious impact on the outcome, which
Well,
means
it might be a little different if you had that indictment and the jury rendered a general verdict of guilty.
yes, Your Honor. I think
Don't you think?
it would be different. I think that's the standard that you would look at, though, would be uncertainty wouldn't be enough. The defense would have the burden. This court held this in Reed just a couple of weeks ago. I don't know if I have the citation handy. It's recent. It was about Somali pirates, but I can't remember the citation. The question would be, can the defense meet a burden to show that the jury relied only on the infirm predicate? Here they can't do that. I don't think if this court concludes that the statute is divisible, I think it's as clear as can be under any standard.
But in future indictments, you under 924C and J, you could readily have 3 counts in this case, or how many? 4 counts.
Word.
4 counts. 1 premeditated murder, and then felony murder with respect to the different offenses.
Yes, Your Honor.
And you'd have 4 counts, and then the jury would be returning very clear verdicts on guilty or not guilty on those 4 counts.
Yes, Your Honor. And I can tell you from much experience, we've significantly changed the way we charge 924C
But
cases.
Judge King says somebody had enough foresight to give this verdict form, which makes this one pretty clear in terms of what the jury did.
I think that's true, Your Honor. And in the Reed case, it was enough to show that the evidence was very strong. And here, this court already called the evidence of murder overwhelming.
Do we know what the were there instructions with how to the jury on how to fill out the sheet where they checked all three?
There were instructions. I'm a little fuzzy on the specific details. The defense is correct. There was an instruction that there was an instruction the jury had to be unanimous, and then they were told you can find.
And the defense says the instructions were flawed. He's saying that they're messed up.
Well, I don't think so, Your Honor. The court.
I thought you'd say that, but
the court.
I think maybe the question is whether the jury verdict fixes them.
I think so, absolutely. To the extent there is, there's no question the jury had to find this unanimously because they did. It says that right here, that we, the jury, unanimously find the defendant committed the murder with premeditation.
But you can't. Sorry. Go ahead.
I was just going to say, in this case, we don't have to have blinders on, but the jury had facts that were about as egregious as you could have them.
Yes, Your Honor.
And they probably would have checked any box you asked them to check in view of these facts.
Yes, Your Honor, and that is a relevant point.
I don't know if it's how relevant it is after Davis. I would have said that a proof of the underlying felony would be part of the 924C crime. But as you know, the Supreme Court split on that recently. And so that we have another complication there.
Yes, Your Honor, I understand that. But even if this court determines that the offense is divisible, if this court goes to the next step of deciding what was the predicate offense the jury relied on, it can consider the overwhelming evidence to do that under Reed. This court held that specifically. I can give the court the citation of that case. I apologize for not having it.
I wish you would give me the citation to the instructions that the district court gave with respect to this jury form.
Oh, I apologize, Your Honor. I don't have that at the ready, and it's not part of the joint appendix. I will make them available to I think they're only available in paper too, so I'll make them available to this court soon.
I don't have the whole thing here, but my colleagues do. They can.
I mean,
they're stronger.
The instructions would be in the transcript, wouldn't they?
They are in the transcript.
What the judge said from the bench would be in the transcript of the proceeding.
Yes, Your Honor, and I have those in a box. We didn't put them in the joint appendix.
Right. They got to be available. I mean, I'm not talking about what the written instructions supposedly were going to be that were handed up, but what the judge said from the bench to the jury.
Yeah, I believe I have that in a transcript that I can get to this court, not at the moment, but soon.
Right. Okay. Maybe you could do that. And maybe there are actually also some sort of other instructions that I don't know.
Why don't you submit the jury instructions given by the court to the jury within 10 days?
Certainly.
Not for the panel. Okay.
Certainly.
Anything else?
Well, we've discussed in some detail in our brief aggravated sexual abuse, and we've discussed what we think this court ought to do if it disagrees with us on the merits of those issues. But if this court, and I'm happy to answer any questions the court may have about any of those issues. If this court doesn't have any, I will yield the balance of my time to the court.
Thank you, Mr. Enright.
Thank you, Your Honor.
Mr. Childers.
Thank you. Just a few points very quickly.
Mr. Childers, before you start, do you have with you the instructions that the judge gave to the jury?
I don't have them, but I can point you to pages 12, 46, and 47. I'd like the opportunity to point the court to some specific instructions that were given, because I know that
those are the page numbers of the
transcript. Yes, and shortly thereafter
of the transcript, not the JA, the transcript, the record you're talking.
Yes, the record,
the trial record.
The trial record. Yes. And the judge very specifically said, without question, he said for the general verdict form for murder, he instructed the jury that they did not have to agree on whether unanimously. Well, he said it had to be committed with premeditation or during the course of a felony, consistent with the common law and consistent with Shad. And the judge said, only after you've reached your general verdict, then do you move on to your special verdict. So the initial guilty finding of murder in this case mirrors Shad. It mirrors the common law.
Yeah, but the point that's, good for you, that's fine. But what I'm interested in is what these check mark beside each one of these items means, and whether the court instructed them on what they meant.
The court, the instructions, I'll be honest, are not entirely clear to me, but
Okay.
but to me, my interpretation of them is that they relate to the 924J finding, because under 924J, to be punishable by death, a killing has to result that is a murder as defined in section 1111. So there's another murder finding in 924J in addition to the 924C finding. And that's what the specific verdict form relates to. Now, I will just again emphasize.
That's just not what it
provides
says.
an instruction to the jury because the form itself says you have to find a unanimous verdict on each of these check marks.
Well, it doesn't say you have to, it says if you have. And then it says, the jury says,
We unanimously find.
Yeah, we unanimously find.
You would agree that the verdict was unanimous?
Yes, Your Honor, as reflected on the verdict sheets. My time is up. May I just answer that very quickly?
Yes, of course.
Again, I just want to emphasize that the reason we look at the indictment and the Shepard documents in this case is to make a determination of whether or not the crime of first-degree murder is indivisible. And felony murder has been part of first-degree murder and not a separate crime since the common law. And since the Shepard documents don't speak plainly and they don't establish with certainty that it is divisible, then this court must treat it like it was under the common law as an indivisible statute.
All right. Thank you very much.
Yeah, can I ask you one question?
Sure, of course.
I noticed you're with the Public Defender's Office in Philadelphia. How'd y'all end up in this case?
Well, we're a community defender, so we have a large capital habeas unit, and because we're a community defender, we can take out of district appointments, and we represent a lot of people on federal death row.
You provide your special expertise above the level of the rest of the lawyer community.
I don't know if I would say that.
Yeah, well, I think that's your compliment you get.
You all are to be commended.
Yeah.
Yes.
Thank you.
Yeah,
Really good work.
I want to say what we would do now is come down and greet you, and we'd probably spend some time with you and thanking you for your representation. This is an important case. It's a difficult case, and we appreciate your arguments on it. Same with the government. And as you know, the tradition in our court is to come down and shake hands, and we're still enforcing the protocols that we've had for in-court hearings, which is the mask and not shaking hands and that type of thing. But many thanks for your arguments and good job. And we'll proceed on to the next case.
Thank you.
Thank you, Your Honor.
Case of Reddy versus Buttar, and we're going to hear this argument by remote. We'll hear Mr. Thomas and Mr. Bondurant. Can you both hear us?
Yes, Judge.
There they are.
Okay, Mr. Bondurant, you're on mute, but I gather you can hear us.
Yes, sir, I can.
Okay. All right, we'll hear from Mr. Thomas first.
Good morning. May it please the court. My name is George Thomas, and I'm counsel for appellant Dr. Rashid Buttar. To give a brief background, in 2010, Dr. Buttar engaged in negotiations with Mr. Reddy, the appellee in this case, concerning some parcels of land in the Philippines. The two men sought to complete the transaction through a sale and transfer of shares of the underlying companies that owned the property. And it was at the time of these negotiations that Dr. Buttar was a citizen in the United Kingdom, and Mr. Reddy was a citizen of the United States residing in Vietnam. This case came before the district court in the Western District Court of North Carolina to enforce the arbitration award granted to Mr. Reddy by the Singapore International Arbitration Center. And it is appellant's argument, first, that the district court did not have personal jurisdiction over Dr. Buttar. And secondly, by Mr. Reddy's failure to provide the latest signed complete agreement, the court lacked subject matter jurisdiction. And assuming that they did have subject matter jurisdiction, summary judgment enforcing the award is contrary to public policy. And it's for those reasons that appellant respectfully asked this court to reverse the summary judgment holding, and in the very least, tell the lower court that there needs to be some sort of evidentiary finding. Moving to the issue of personal jurisdiction, this court well knows that first, I think it's important to note that this is a question of general jurisdiction. And this court well knows that in order to enforce or to invoke general jurisdiction over an individual defendant, and I think that's important here because a lot of the cases cited and relied upon in the lower court and in the briefings before this court concern corporate defendants. But over individual defendants, the court must look at the defendant's domicile, which can be defined as the last residence where, in this case, Dr. Buttar intended to remain permanently or indefinitely and to return whenever he's away. The district court ultimately, after a jurisdictional discovery, ultimately found that it did have personal jurisdiction over Dr. Buttar. And we would assert that that's simply not the case. Dr. Buttar moved from North Carolina to New Zealand in 2017, over a year prior to this suit. Although he was the face of a medical practice, the Center for Advanced Medicine.
Just with respect to that assertion that he moved to New Zealand, is the only evidence, he has no home there or no residence there. You provided a visa. Is that what it was you provided in the record?
Yes, Your Honor. He does not.
That's the evidence we have before us. And I was going to ask you about the question raised by your opponent that is a manufactured document and not authentic. Do you have any response? Have you checked on that?
Your Honor, I will be candid. I did speak with Dr. Buttar a few days ago, and it was very late in the evening for him given the time change. However, there was a point in the district docket number 43. There's an affidavit from New Zealand Council that he assisted Dr. Buttar in New Zealand for obtaining New Zealand permanent residency, which takes over a year over a half year from when you're granted.
Well, I'm asking you about this document that's in the record. It's the only evidence I saw that in furtherance of this allegation. And the suggestion made by an immigration expert in New Zealand is this is a manufactured document and not authentic. My question is, when you received that affidavit, did you check to see whether you were advancing a manufactured document as opposed to an authentic one?
It was our understanding that this was an authentic document. That's
where did you get that information?
From Dr. Buttar.
After this allegation came.
And did you ask him after this allegation?
Yes.
And what did he say?
He said that this was prepared by an attorney in New Zealand, and there was I was provided no indication that this was a manufactured document.
So we have no contact with any official authority in New Zealand. The reason I ask is not only does the document contain the suspicious account number that was noted by the immigration lawyer, but it also only shows 8 digits for the passport number. And the passports in United Kingdom and United States all have 9 digits. And I didn't see anything of certified or stamped on it or sealed. It looked funny to me, and I'm so wondering whether you, as an officer of the court, were continuing to advance the document if you had serious doubts as to whether it was authentic.
Your Honor, I do recognize what the immigration expert stated, and I believe that there are questions. What alleviates
I mean, it was very easy to get the official certified copy of the visa from New Zealand, from the immigration authorities there.
I'm sorry, Your Honor, could you repeat your question?
Well, I would have thought that it would be fairly straightforward to have somebody there get a certified copy of the visa from some New Zealand authority, immigration authority there. Anyway, if you haven't checked it, apparently you didn't check it, and you just relied on Mr. Patar's statement.
Oh, yes, Your Honor.
And Mr. Patar is in, you say he's living in Vietnam?
Dr. Buttar is living in New Zealand at the moment.
In New Zealand.
Yes, Judge.
And he's staying in a friend's house?
That is the current understanding, yes.
Okay.
You don't know?
I can't say for certain. There's just the lack of documentation. I mean, admittedly, it's difficult to ascertain exactly what the living situation is. I know that he moved in 2017 to New Zealand with a...
And he moved all his goods into a warehouse in North Carolina, right?
I believe that it was mixed between North Carolina and Texas.
Yeah, but he has, in North Carolina, he is renting a storage facility, right?
That is correct.
And the district judge ruled against you as a matter of fact on the North Carolina issue.
Yes, Judge. The district court ruled that the continuing contacts after Dr. Buttar moved and the lack of concrete proof that Dr. Buttar was in New Zealand kept him eligible for the court to exercise personal.
He found against you as a matter of fact, and we review that for clear error.
Yes, Judge.
And with respect to his business, he continues to have a contractual supervision over employees of his former business, doesn't he?
I believe that Dr. Buttar only gets paid.
I didn't ask what he got paid. He's exercising contractual supervision over people that need to have a doctor sponsoring them.
Yes, Judge.
That's what he testified.
And in his divorce papers, he provided that his address in North Carolina was his residence.
Yes, Judge. However, I do
Find
think
that he said the lawyers just made that up.
Excuse me, Your Honor. I'm sorry.
And he asserted when asked about that the lawyers just made that up in order to facilitate the proceeding.
Yes, that is what Dr. Buttar's stance was in terms of the divorce proceeding in North Carolina. To the second point, even if this court did have the lower court had personal jurisdiction over Dr. Buttar, the fact of the matter is that Article 4 of the New York Convention specifically requires that a party seeking recognition of the award must supply the court with the original or certified copy of the agreement and the arbitration award together. And there is no dispute that Mr. Reddy provided the lower court with a copy of the award. However, there is a dispute of whether the agreement, a valid agreement, was presented to the court. And this is
the copy attached to the amended petition. It's in 380 something page of the record, is a fully signed copy of the agreement, and it's certified by the magistrate in Singapore as the document that was adjudicated there. How do we handle that?
Well, Judge, the point with that document being certified is first that was not that document. It's Dr. Buttar's stance that document was not the last agreement fully signed.
Well, that's the one that was before the arbitrator as certified on the face of the document. That was the one that was adjudicated in the arbitration in Singapore. And so the question is, your argument is that, and you state in your brief, they have consistently failed to present a signed and executed final agreement between the two men. You've said that twice in your brief, but yet the record at 389 contains a copy of the document signed by both men and certified by the magistrate in Singapore. Now, how do we handle that? You just said a true test copy would be sufficient. That's what they provided.
Judge, it's our position that this was not the latest document, and in fact, Dr. Buttar's signature was.
Well, why didn't you tell the arbitrators that?
Well, the reason is because the latest document agreed on the Philippines being the forum for arbitration. So,
no, my question is, when the arbitration began in Singapore, why didn't your client go and point out that this was not the final document, even though it's fully signed? This is not the final document, and that the final document you could have provided the final document challenging the Singapore location.
Your Honor, I'm out of time. May I please respond?
Yes, please do.
Well, the reason Dr. Buttar did not contest this in the Singapore arbitration was because his counsel overseas advised him not to engage in any sort of arbitration and appear before the arbitrator in Singapore, because that would essentially be an admission and acknowledge that that was the final document. So without a responsibility.
So that was a strategic decision made. In other words, the alternative would be to go to the arbitrator and say he has the wrong agreement and that this should be in the Philippines. But that wasn't done. And not only that, his attorney did file a paper with the arbitrator, didn't he?
Yes, Judge, but Dr. Buttar.
Well, why isn't that an appearance in the proceeding?
I mean, to your point, Judge, it is a type of appearance in the proceeding. I think the strategy was more of not availing himself to Singapore.
Well, I understand the strategy, but then it's hard to come in later and say after the arbitration that the arbitration didn't have an agreement when it did have an agreement and acted on an agreement. That you argue is the jurisdictional basis for the enforcement under the treaty. And so you're facing a situation where they did provide the contract, and you say you didn't provide the contract. You say that the real contract provided for a Philippines arbitration, but the contract that was certified by the Singapore arbitrator said it was arbitration in Singapore. But isn't that all something to be handled by the arbitrator and not by an American court enforcing that?
Well, I do think that American courts in enforcing arbitration awards are required to ascertain whether a valid arbitration clause was entered into. And if the contention is that what was presented to Singapore was not a valid arbitration clause, then summary judgment was improper.
Well, I don't see any basis where you show did you provide a ultimately signed copy in this proceeding to even challenge that?
No, Judge. The unfortunate fact is that the logistical challenges of Dr. Buttar being in New Zealand, even during jurisdictional discovery in the lower court, it was difficult to ask to locate and present the final agreement.
All right. Thank you. All right. Well,
thank you, Judge.
yeah, fine. Thank you, Mr. Thomas. We heard from Mr. Bondurant.
Thank you, Judge Niemeyer. May it please the court. Joel Bondurant here this morning on behalf of Rashawn Reddy. I actually don't intend to take a whole lot of time. I just want to go over sort of what the arguments here on the issues. And I'm going to start where your honors kind of left off with this question of the challenge in the arbitration, because the truth is they did raise it in the arbitration, that they raised the argument in the arbitration, in the submission that they made to the arbitrator, that the argument that the agreement, the duly signed, jointly executed agreement was not the actual final agreement. That argument was submitted, documents and evidence were taken, and the arbitrator ultimately ruled against them on that, calling that argument disingenuous for several reasons. And that was the basis of the district court's finding that they were even collaterally estopped from raising all this stuff. Aside from everything else, there's a collateral estoppel finding by the district court that wasn't even challenged on appeal. So we got a fairly substantial obstacle there. But with having said that, let me just sort of turn and address these issues in order: the personal jurisdiction, then the subject matter jurisdiction, and then the summary judgment finding. On personal jurisdiction, as your honors are well aware, and we've been point of discussion, that the issue was domicile, and we would submit to the court that the Judge Whitney's analysis is a virtual model analysis. I mean, it steps through the legal principles of domicile. It weighs the facts. It acknowledges the need to take a totality of the circumstances approach. It does that. The judge explained why he was crediting certain facts and evidence over others, and why he discounted others. And he found, as a matter of fact, as Judge King was pointing out, as a matter of fact, that the domicile had not changed from North Carolina as of the time that the lawsuit was filed. And that is a finding of fact reviewed for clear error. And so the court could only reverse that if it was left with a definite and firm conviction that Judge Whitney made a mistake. And so with that, I'll kind of leave that there unless your honors have any questions. I mean, again, the factual analysis was pretty good. There's several alternative bases for holding personal jurisdiction. Those are asserted in my brief. I don't really intend to spend a lot of time on them. We raised judicial estoppel in the district court on the basis of the divorce documents that your honors mentioned. Judge Whitney just declined to address it because he ruled in our favor on the domicile issue. We also had the argument that even if it's not his domicile, his contacts with North Carolina had been sufficiently systematic and continuous over a sufficient period of time for general jurisdiction. Judge Whitney disagreed with that argument in a footnote, but again, didn't elaborate much because he ruled with us on domicile. Also, we got the possibility of transitory jurisdiction because we tagged him while the case was being in the motion stage. We knew he was.
But he asserted in his brief that he was never served in the United States, and I looked into the record, and it looked to me like he was in fact served. He refused to take the papers. He was advised that the papers were suit papers, and he was told what they were, and he refused to take them. So that the server laid them on the ground there in front of Mr. Buttar, and then surveyed the situation, and Mr. Buttar came back and picked him up and left.
Yes, sir, that's accurate. And so, yeah, that's
I think he'd seen too many movies about served or not. So maybe you want to get on to your other arguments.
Oh, yes, ma'am. So subject matter jurisdiction, I'll just hit briefly. As the court's well aware, subject matter jurisdiction just deals with the category of cases that the court's is authorized to hear. Here it plainly is arising under 1331 because it's a petition under the Federal Arbitration Act. The act itself says that jurisdiction is appropriate in the district courts. And so the argument really has been that failure to provide the duly signed document at the outset, the duly signed agreement, somehow affected the court's subject matter jurisdiction. But as we elaborated on in our brief, there's just no legal support for that position. The facts themselves don't dictate the court's subject matter jurisdiction, the statutes do. And as the court has already noted, we did a motion to amend, which was granted, which did submit the duly signed agreement, as part of the exhibit. And under a wealth of authorities about a mile long, any amendments would relate back and could cure any subject matter jurisdiction.
Well, that's not been challenged here.
Right.
The amendment is not challenged.
Exactly, Your Honor. Thank you. And so, but subject matter jurisdiction is. And so briefly, even if the court thought there was a subject matter jurisdiction with the original submission, the subsequent amendment would have cured that. So no issues there. Summary judgment. On the question of summary judgment, that's the third ruling that's before this court. Like I said, there's a huge hurdle here in that the district court, Judge Whitney found that they were collaterally stopped from raising these issues because their sole issue that they've repeated throughout the proceeding has been this claim that somehow this agreement is fraudulent. The agreement that contains the arbitration clause is somehow forged or fraudulent. Judge Whitney found that they were collaterally stopped from raising that because they raised it in the arbitration and the arbitrator ruled against them. Now they subsequently decided, as Mr. Thomas.
I'm not sure collateral estoppel is the right doctrine. It seems to me if an arbitrator decides something, then it's our deference to the arbitration finding.
Yes, Your Honor. I understand
that governs that. We don't go back and review the facts of an arbitrator.
I understand that, and that certainly is an alternative possible way to resolve it, and we certainly made that argument in the lower court and in our brief. There is case law that an arbitration award is collateral estoppel, but we can also.
Well, an arbitration award would have to be collateral estoppel in a court, right? Have been enforced in a court. I mean,
I think the actual arbitration.
The arbitrator has no force of law until it's enforced in a court. This is a contractual arrangement.
Okay. I understand the point, Your Honor, and if that's the way the court is inclined to frame it and view it.
I'm questioning you.
Oh, no, I understand. It was my understanding, and I didn't probe it admittedly at that depth, but it's my understanding that an arbitrator's decision can also be collateral estoppel. And I thought we cited some law in our brief to that proposition, but perhaps I didn't plumb it deep enough, and perhaps there is more of a procedural requirement that it be registered in order to be collateral estoppel. I didn't see that, but in the event that it is solely a deference issue, the point remains. I mean, the arbitrator decided it. The courts regularly defer to arbitrator decisions. This, as a matter of fact, this whole issue of whether or not the arbitration agreement is even valid is not even one that's not even a valid challenge under to a registration action. I mean, again, I briefed that thoroughly in our brief.
Has the doctor ever produced this, what he regards as the genuine agreement, which talks about the Philippines being the place where the arbitration should have taken place?
No, ma'am. I've never received any. We've never received any admission from Dr. Buttar that there is some alternative signed agreement. We've never gotten anything like that.
Well, there's an admission by him, but that's his whole argument, I think. But he's never sent you a copy of that or produced it to the district court.
No, ma'am. We don't have that. And as Mr. Thomas.
Or produced it to the arbitrator.
Correct, Your Honor. And again, the arbitration award, if you review that section of it that deals with the first objection, which is at page, let's see what page that is of the. Well, why is it not showing up on my screen?
We can find it. Don't.
Okay. Sorry about that. But at any rate, it's if you review that section, it's very plain what evidence was submitted to the arbitrator in that connection with that issue, and it was the duly signed agreement.
But we don't review arbitrators for the substantial evidence doctrine. They hear the dispute. The parties can put in what they want, and the arbitrator makes a finding. Right. And the only issue is whether we enforce the arbitration award. And that's based on criteria that are established by the relevant acts, whether it's the Federal Arbitration Act or in this case, the Enforcement of Arbitration Awards Act, New York Convention or whatever that is.
Yes, sir, I agree, which brings me back to the point that I was attempting to articulate, which is that The grounds, as you know, as the court knows, are very limited in what you can do to challenge an arbitration award. And this challenge that they're trying to mount is not one of them. The case law and the authorities are fairly clear that even if you want to challenge the validity of the underlying agreement, that has to be done in what they call the primary jurisdiction versus the secondary jurisdiction, and the primary jurisdiction being the jurisdiction that actually issued the award. So it would have to be Singapore here if they wanted to try to bring any kind of challenge to the validity of the award, assuming, the validity of the agreement, assuming they were able to do that. But they can't raise it here in the United States federal courts when we try to get it registered and enforced, and there's just no basis for doing that. And again, I guess I'll just close unless the court has any questions with the facts.
I have a question really about the facts of this case. So if we should affirm here, what is happening with this property that, as I understand, is at stake?
Your Honor, the property itself, my understanding is, of course, I wasn't involved at that stage when that was going on. My understanding is it was some type of share purchase agreement to develop the property. I don't know that it just never got off the ground, is my understanding. And I think that's what kind of gave rise to the original proceeding in the arbitration, was just claims that these were basically fraudulent solicitations of investments and the like, which is how they wound up getting the arbitration award that we're now trying to resolve as,
So money is at stake?
Yes, ma'am. We got a arbitration award is in the neighborhood of about 1.5 million. So,
and is that money is there a bond for it or something while this appeal is going on?
No, ma'am. There's no bond for that. The truth is we don't frankly know at this point whether or not, we don't know if we're going to wind up with an uncollectible judgment, in essence.
You don't know what?
I don't know if we're going to wind up with an uncollectible judgment. I mean, he's not, he does, we don't
Evidence in the record, you're not going to find any assets, but he seems to have a pretty good supply of money. His traveling and his
right.
And his interest in the thing here that you talked about earlier, his business here.
You want the judgment so you can try to collect it.
Yes, sir. That's ultimately, this property that you hear mentioned in Huntersville. There's some question about, how it was transferred to some entity that's less than transparent. And so there's some question about, that used to be his residence, and we don't know if we can get
transfers to avoid debts do create a problem for transfer or, All right. Anything else?
No, sir. Unless the court has any other questions, I'll wrap it up.
Thank you, Mr. Bondurant. Mr. Thomas?
Thank you, Judge. Just briefly, Mr. Bondurant mentioned that the only issue that can be considered before the courts is whether the arbitration award can be enforced. And I'd just like to point the court's direction to VRG Linus Arias versus Matlin Patterson, where the court specifically states that if the parties agree to arbitrate in the first place, only the court can answer questions of arbitrability. And so I do believe, just a slight point of contention is that if there is a contention over the validity of the arbitration clause, that is something that this court can consider. Second,
I would think there is always a discussion under the FAA cases about whether arbitrability is a contract issue for the courts or an issue committed to the arbitrator to resolve. But in this case, there's a pretty clear arbitration clause, and the commitment of this issue to the arbitrator looks pretty clear, but I don't see that was ever challenged. In other words, the subject matter of the arbitration of what the arbitrator addressed appears from the face of the clause and the dispute to be within what the arbitrator could adjudicate. So your argument would have to be that the contract did not give the arbitrator the power to do what he did. And if you accept that the arbitrator found that was the governing agreement, if you find that agreement provided for arbitration of these issues, basically it's a return of money. I understand that Mr. Reddy advanced $1.5 million in cash, and never got it back when the project failed. And so the question is, why isn't that appropriate for arbitration under the agreement under which the money was advanced?
If this court were to find that the agreement presented to the Singapore Arbitration Center was in fact the final agreement between the parties, then that would be the case.
How can we decide that? I mean, that was presented to the arbitrator. Apparently you challenged that, right? Before the arbitrator?
Yes, Judge.
And the arbitrator overruled your objection or rejected your position. So now, how are we in a position to say the arbitrator was wrong?
Well, I believe that the district court was in a position to at least move forward with the proceedings and not grant summary judgment because there was this contention of fact.
Well, you contended and it was rejected. I mean,
Yes,
I don't
Judge.
know how we review an arbitrator's finding of fact, how the district court can review it, how any court can review it. The parties contracted to resolve their dispute by arbitration, and the various countries, including the United States, have arbitration rules. And if you follow the rules, then we enforce those contracts or we don't. Now, if the contract itself was obtained by fraud, we could set it aside, but there's no evidence of that. As a matter of fact, there's a finding that that was the contract, the governing contract, and you could challenge that. You could have produced the other contract. You could have produced facts saying that this was not the final version, although it's all signed and it's certified by the magistrate. But those are things that are presented in the arbitration, and they're not things that I'm not sure how we would address them. If we were to address them, I don't see any evidence from you as to how we would sustain your position. I mean, you've conceded the real agreement is not available, at least your alleged real agreement. And
Yes, Judge. It is our understanding that the real agreement, just given the logistical challenges, would need increased time and resources to.
I don't understand that logistics. I assume that Mr. Bitar has a copy of it, and he would have it in either one of two places or three places, either with him in New Zealand, if that's where he moved, or they're still among his belongings in the storage facility in North Carolina and Texas.
Yes, Judge, that certainly is a valid possibility. To that extent, I don't know how to, just candidly, I don't know how to sufficiently explain to the court why.
Well, I understand your problems. I'm not focusing on you. You had a difficult circumstance to handle here.
I would just like to close by saying that there are ways where the lower court could refuse to enforce the arbitration award, and those being public policy. And if
What's the public policy? What's the public policy? Why is this against the public policy to order the return of monies on a project that never went forward?
Well, the issue is, do we want United States district courts to enforce an award on an allegedly fraud agreement? And perhaps
Well, the fraud is gone. You had the possibility of alleging it and proving it, but you've produced zero evidence in that regard. You could have produced the document, you could produce exchanges. As a matter of fact, the email exchanges suggest there was an agreement. As a matter of fact, Mr. Bitar was trying to enforce the agreement against Mr. Reddy and telling him he had expenses under the agreement that need to be reimbursed. There's a lot of inconsistencies in here on that. But I don't understand the public policy. I mean, if we had evidence that it was fraudulent, I don't think we would enforce it, and you'd have a pretty good case.
Yes, Judge, that is simply our position. And I do appreciate the court's time and the court's questions. I see I've run out of time, and I do appreciate your time.
Well, thank you, Mr. Thomas, and I hope everything goes well in your household there with the COVID situation.
Thank you. I have
yeah.
family visiting. We're
Yeah.
excited to see them, but a little weary.
Yeah. Well, we would normally come down and greet you. In this circumstance, it's even more remote a possibility. But we thank you for your arguments. And you come to the court again, we will come down and shake your hands at a future date. All right, we'll take a short recess and then proceed on the next case. You want to recess? Yeah.
This honorable court will take a brief recess.
All right, be seated, please. We'll proceed to the next case, Cantwell Cleary Company versus Cleary Packaging. And I guess we'll hear first from Mr. Fasano.
Good morning, Your Honor. May it please the court. When Congress enacted the Small Business Reorganization Act of 2019, it dramatically transformed the statutory framework of Chapter 11 for small businesses based on pre-existing models of reorganization available to family farms in Chapter 12 and to individuals in Chapter 13. In doing so, Congress recognized that for a small business, there is such an identity of interest between the business and its shareholders that traditional Chapter 11 rules were illogical. There are four important differences relevant to this case between traditional Chapter 11 and Subchapter 5. First, there is no longer an absolute priority rule, just like in Chapter 12 and Chapter 13. That means shareholders can keep their equity in a corporation without putting in new value or paying all creditors in full. This is hugely important, and as this court has said, represents a sea change from the prior practice.
Is Chapter 5 set up the same way as Chapter 12 is for farmers and fishermen?
Chapter 5 takes some provisions from Chapter 11, which are set forth in 11 U.S.C. 1181, and it says certain provisions of Chapter 11 do not apply.
Right.
And one of the provisions it says does not apply is 1141D, which governs the discharge for confirmed plans of reorganization. When there's a non-consensual plan of reorganization, Chapter 5 includes Section 1192. And 1192 is the exact same language as Chapter 12, taken from Section 1228 of Chapter 12.
Is there any indication when the act was passed that Congress intended that small businesses and farms and fishermen would be treated alike?
Yes, Your Honor. I believe that the act was created based on Chapter 12 as a framework. Chapter 12 has been the sole framework whereby a debtor can reorganize without having the absolute priority rule. So you're entitled to keep your farm without paying all creditors in full. And so when they tried to make Subchapter 5 into a chapter without an absolute priority rule, they took the provisions of Chapter 12 and transplanted them into Subchapter 5 as appropriate.
Just as an aside, it's up to you, but you're welcome to take off your during argument. We've allowed that under our protocol, but that's only if it's comfortable with you.
I appreciate, Your Honor. It makes my glasses not fog up, so that makes everything easier. So with no priority rule, it was necessary to add Section 1192. In traditional Chapter 11, you either had to pay all your creditors in full, in which case it wouldn't really matter if you could discharge these fraudulent debts, or you would have to sell the business to new equity, and new equity shouldn't be charged with the sins of the prior owners of the company. But without an absolute priority rule, you have the shareholders who committed the misdeeds and still in charge of the company, but they're only paying pennies on the dollar. In this case, they're proposing to pay 2.5% of our judgment over 5 years, and they're keeping all the equity in the company and paying their.
Go back to the structural question I was asking you. You said that the Chapter 12 provision, comparable provision, has been construed unanimously, I guess, to exclude the discharge of debts of the kind in 523A.
That's correct, Your Honor.
And that applies to both entities and individuals?
To both entities and individuals. And that was the background.
And so that's what you're advocating was the intent here, despite the difficult language in 523A.
Right, because the operative discharge provision is 1192, not 523. So 1192 refers to debts of the kind specified in Section 523. That's the same language that's used
in a 1192 can be an entity or an individual.
It could be an entity or an individual. For instance, 1192 also says you can't discharge debts paid over 3 to 5 years. that applies to both an entity and an individual. So that is
So your argument that 1192 is the governing provision which applies to corporations and individuals, and that it prohibits the discharge of debts of the kind in 523A. And in going to 523A, you would eliminate the introductory language, which contains individual debts, and just put the description of the types of debts.
I wouldn't say I would eliminate it. I think it still applies to ensure.
It's a difficult provision. It makes, I mean, the district, Judge Harner wrote a pretty well-crafted opinion here, and in focusing on that. So I think that's the rub in the case. If that word individual were not there, and your argument, I gather, is that 1192 governs both individuals and corporations by definition,
Right.
and that it eliminates from discharge debts of the kind in 523A. And that's that means fraudulent type debts and things like that.
Correct, Your Honor. Debts of a kind, not debtors of a kind, specified in 523.
And you can go to what you were saying. I just wanted to understand the structure in the bankruptcy code.
Certainly, Your Honor.
This comes up here as a direct appeal from the bankruptcy court because there's not much law on it,
There's almost no law on this issue.
almost no law. So this be the first court of appeals decision on it?
The First Court of Appeals, and there's,
You all skipped the whatever that provision is.
yes, we use,
Come directly to the Court of Appeals because everybody agreed to it.
everyone agreed to it, Your Honor.
So who decides our jurisdiction? The court here or you all?
The bankruptcy judge certified it for direct
I
appeal.
understand. They certified, then the bankruptcy judge decides the jurisdiction of the Court of Appeals or the Court of Appeals decides its own jurisdiction?
The Court of Appeals decides, and
Well, nobody's briefed jurisdiction. You just told us that everybody's certified.
I believe this court,
So why were you doing it? Because it's so important?
because
It needs to be decided? Maybe you got an argument to make that it should be heard here.
I believe it should be heard here, Your Honor. If this was
I'm
appealed,
glad to hear that.
I believe if this,
We're all here, it's been briefed.
thank you, Your Honor.
Just to follow up on Judge King's question, you're under 158, right?
Yes, Your Honor.
And what does it require? Is it like 1292B where it's certified and then the Court of Appeals has to grant permission?
Yes, and they did grant.
And we
permission.
granted permission?
Yes.
Oh.
Yes. So we are here before the court on a properly granted application.
So we have a panel that previously ruled that we have jurisdiction here.
Yes, Your Honor.
Oh, okay. I wasn't aware of that.
I believe so, Your Honor. I'm
I
doing
think
this.
that's right. I think there's
So
a.
that's the case.
Yeah, yeah.
That takes care of it. I just didn't,
Your Honor, I'm about out of time, so I would reserve.
I was taking your time. You go, I apologize.
Take another couple minutes.
Thank you, Your Honor. Your Honor, this of the kind language, it's the exact same language that Congress used in 1141 D6, which is how they specifically made 1141 D6 applicable to corporations. It's the exact same language as section 1228, which is the language that they use for family farmers. There's two cases on 1228. They've been briefed in our papers, the Breezy Ridge case and the JRB Consolidated case. And what those cases say is, first you look at the specific chapter-specific discharge provision, which in this case is 1192, and that applies to both corporations and individuals. And then once you've determined whether or not that applies, then you would look at section 523. But 523 is just the exception for individuals to 1192. The operative provisions of 1192 say that debts of a kind specified in section 523 are non-dischargeable. And so we believe that if you had not included 1192 to the preamble to 523, every individual debtor's lawyer in the country would say, hey, I've got an individual, they can get rid of all this fraud debt now. So they had to include it for that reason, even though it's redundant with the provisions of 1192. And this argument about superfluousness, I don't really think it makes sense.
Well, just let me pose the argument I think that the other side will present, and that the bankruptcy judge did. The argument would be debtor in 1192 is both business and individual, and it accepts from discharge debts of the kind in 523A. 5320A defines debts of individuals relating
to corporations trying to discharge debts under section.
So what do you make of the kind language? What do you think? What do you think it means? I think you said this earlier in your argument, but
When a corporation commits a fraud, or in this case, intentional tort of the kind specified in section 523. So this is a tortious interference case. That would be of the kind specified in section 523 because an individual could not discharge that type of debt.
so it doesn't relate to who did it
It does not
or
relate
what they
to-
did.
That's correct. Your Honor. It modifies the term debt, not the term debtor. Your Honor, if the applicability of
Well, you know something, your hesitation reminded me, I gave you 2 minutes and we're now almost 4 minutes.
I apologize, Your
No,
Honor.
we got more time, but we'll get you back.
Thank you, Your Honor.
Sure thing. Mr. Brandman, I think you're up next, right?
May it please the court, Robert Bramman for the United States, appearing as amicus on behalf of the appellant. I agree with, we agree with the arguments ably
You
made
represent the
by.
Bankruptcy Department of the United States?
I'm with the tax division of the Department of Justice.
I'm pulling your leg a little bit. But
Okay.
I understand. Thank you.
The United States is the biggest creditor in bankruptcies.
Was the Department of Justice involved in the drafting of this legislation? Like, did it come over from Congress to get your approval?
I don't know, not to my knowledge, but that's not something I would normally know about. The legislative history is fairly sparse on a lot of the bankruptcy amendments.
Why was the whole 2019 changes made? It looked to me like they were trying to carve out small businesses to be treated like farmers and fishermen. I may be wrong on that. Is that what's revealed or not?
They were trying, it seems like they were trying to carve out for small businesses a more streamlined form of reorganization like they had previously for farmers and fishermen, yes. Our view is that Judge Harner simply used the wrong interpretive tool to try to figure out what Congress had done in the Small Business Reorganization Act. Her opinion reflects that she thought that 1192 actually could stand for exactly what the creditor in the United States think it stands for, that the discharge exceptions apply to all types of debtors. But then she pulled out of the interpretive toolbox this provision, this intent to find that every word means something, and applied it to the conforming amendment that added 1192 to that lead-in language of 523. That's a provision that already lists all the other discharge provisions in the bankruptcy code under 7 and 12 and 13 and 11. So it's appropriately described as a conforming amendment, which was how it was classified in the bill. The bill includes that amendment as part of, I think it's section 4, all the other conforming amendments, not one of the substantive provisions of new subchapter 5.
Let me ask you, I'm not fully aware of the whole bankruptcy code, but is there any provision in the bankruptcy code which allows for the discharge of fraudulent debts? In other words, would this be, if we affirmed, would this be the first place in the bankruptcy code that we allow for the discharge of fraudulent debts?
No, In a traditional Chapter 11, corporations can discharge fraudulent debts. But that expansive discharge provision works with the absolute priority rule so that holders of claims that otherwise would be dischargeable are protected, because under the absolute priority rule, those creditors, right, they're going to be paid in full, or they're going to vote in favor of the plan because they see it as a viable option for getting paid, or else equity is going to be canceled, in which case there's no compelling rationale for having exceptions to discharge.
Are there exceptions in 1141 that apply in general reorganizations? Maybe I got the wrong provision.
Yes. Under I think it's in the 523 list are some debts incurred through fraud. Under 1141 D6, debts incurred through fraud to the government are not discharged even under traditional Chapter 11.
I think you hit on what I was thinking about. Yeah.
Okay.
So, but if I could just build on that for a second, because I think that's an interesting point. Absent the priority rule, which certainly I understand, because what you have is, I mean, the discharging by the priority rule of all the assets. Are there rules that allow return of fraudulent debts? I'm still not quite sure I understand that. In other words, you can make a claim for fraudulent debt that will be honored?
Debts that have been incurred through fraud,
yes,
can be discharged by corporations in a traditional Chapter 11.
But that's because of the priority rules, really?
Yes.
Okay. Absent that.
In subchapter 5, with the absolute priority rule abrogated, it made sense for Congress to bring back the discharge exceptions, including for fraud. We answer the question?
I think so. Without the, you can tell I'm not a bankruptcy lawyer, judge, but without the priority rules, is there an ability to discharge a fraudulent debt in the bankruptcy code? Maybe, have you answered that already? Try me again.
The 523 list, as it applies to individuals, includes a number of debts incurred through fraud. And so those are generally accepted from discharge for an individual.
Yes.
But they're generally allowed for a reorganizing corporation in connection with the absolute priority rule.
In connection with the priority rules, but I'm
Yes.
saying if you don't have any priority rules, is there somewhere in the code when you can discharge fraudulent debt?
I don't know of another way to discharge fraudulent debts other than what we've both been talking about.
Okay, thank you.
How much taxes has the government got at stake here?
In this case, I don't know. We were not involved in this case.
I know you weren't involved in this. I'm not talking about this case. You say you're in it because the government collects a lot of taxes.
A lot of debtors
So
go
how
into
much,
bankruptcy.
how much does the government have at stake in what this decision making?
I don't have any idea.
You've got a bundle of money at stake, you're saying.
We have very many debtors go into
You don't
bankruptcy
know.
with unpaid tax liabilities.
No idea.
And frequently they're not dischargeable, not because they're fraudulent, but because they're recent. That's the most common. The IRS, of course, is an involuntary creditor. So we're not in a position to shut businesses down as soon as they miss a payment. So we're frequently last on a creditor's priority list of who to pay. For that reason, tax debts are frequently not dischargeable just because they're recent.
So you may not know right now, but historically, and things may be different because of the pandemic, but can you give us an estimate for 5 years ago?
I can't, not at all, no.
Okay.
How many numbers? How many digits?
I can't answer.
8 or 10?
I can't answer that.
Is that information available somewhere?
I believe it probably is, yes. But
Could you send it to us?
I was just trying to help the court interpret a new statute.
Right.
Okay. Are there any more questions for me? I'm out of time.
All right. Thank you.
Excuse me while I take this thing.
All right. I guess we'll hear from Mr. Sweeney now.
May it please the court, Paul Sweeney on behalf of the debtor appellee. I'd like to respond first with a response to Judge King's question. This is a big deal. The number of tools that we have at our disposal as bankruptcy attorneys are limited. And what Congress passed here is a small business tool. It's not Chapter 12. It is part of Chapter 11. It is a small business tool for us.
I know, but you know, when I ask questions about the farmers and fishermen, the structure is somewhat the same. They're not thrown into the category of Chapter 11, and basically, small businesses don't have the resources and have to give up farms and this type of thing. Congress wanted to treat them in a more streamlined fashion, I gather. And so I was just thinking or suggesting, based on the argument, that maybe 1192 is intended to be parallel to Chapter 12. And you're saying they're distinct. I know they're distinct by terms of statutes. Questions, are they distinct in terms of policy?
There are parallels, Your Honor, for sure, but there's limited parallels. Chapter 12 is a fisherman and farmer provision to reorganize family farms primarily. And this tool is more universal, and that's why it falls more properly within Chapter 11. But the reason why it's important is the expense. And I think both briefs have informed the court about the legislative intent, and that is to get a provision of Chapter 11 that allows the middle market, the moms and pops, to not close their doors. And I think that rationalizes, in addition to Judge Harner's well-reasoned opinion, why the code says what it says. Because this allows a business to pay its debt, including to the federal government, including the taxes, rather than liquidating and giving up. It keeps the businesses open. It keeps small town employers employing people, and it handcuffs them. This is not perverse. This is not absurd. This is rational. You have the ability of a small business, and even if it's as bad as the government and Mr. Fasano would argue to the court, what would we do? Shall you close those businesses and pay them nothing? That makes no sense. This statute actually makes a tremendous amount of sense because it allows over 5 years in a crammed down situation where the creditors don't consent. Golden handcuffs. You are handcuffed to a sub-5 trustee.
But you know, all of that I understand, but the question is whether in setting up something special for small businesses, Congress intended to exempt fraudulent debts, let a discharge of fraudulent debts. And they clearly said you can. And so now, as a matter of policy, they don't want the small businesses to be able to discharge fraudulent debts to the extent that they specified in 1192. And so the whole question here is not whether they're going to allow the discharge of fraudulent debts. Congress said no. It's just a question of how broad that scope is. Does it go to both corporations and individuals? And 1192, of course, doesn't make a distinction, but 523 does make a distinction. So that's the rub, I think. And so I'm not sure you're addressing as how small businesses are benefited and so forth lends much credence to what Congress intended. As you know, bankruptcy is an equitable procedure. You come into court with clean hands, and as an ultimate policy matter, it'll give you a new start, but not a new start from fraud as a general matter.
Correct.
And so the question is, how far did Congress go in this particular provision? And I think that's a statutory construction question.
I think it is too. And I think what Congress did here, it is important to note, individuals and business entities can use subchapter 5. And therefore it doesn't fit perfectly into the chapter 12 family farmer provisions. It does have to adopt a more global presentation. And you cannot escape as an individual. You're an individual and you file a sub-5 bankruptcy with business debt over 50%, then you will be subjected to Section 523A, because 523A has the preamble and
So
it
this
clearly.
mom and pop operation that has fraudulent debt cannot discharge fraudulent debt, but the mom and pop operation, I can, but the mom and pop operation that has an LLC behind it can't.
If you
Same
follow that
size
argument, but yes.
That's the argument.
And it doesn't make any sense, because you can discharge fraudulent debt, to answer an earlier question, in Chapter 11, just normal Chapter 11. Yes, you can.
They're in Title 5, Subchapter 5, and we're addressing that. In other words, this is a recent provision. I don't think there's a single circuit court that's addressed it, and I think getting behind what Congress intended is probably pretty good, but I think if you approach it and start with 1192 and then go to 523, you may get one answer. If you start with 523A and go to 1192, you may get another answer.
Well, I argued in front of Judge Maria Ruark in the Satellite Restaurants case, Crab Cake Factory. She found the same way as Judge Harner. Now, that decision was mooted because the case was later dismissed. The case did not successfully reorganize.
Do you agree that the answer might turn on what the phrase "of the kind" in 523A means?
I don't. I think it's clear.
You don't rely on that?
The statute under 523 clearly refers back to individuals.
No, I'm talking about 1192 says "of the kind."
Correct.
Which they didn't say as provided in 523. They said that's of the kind.
Yes.
So the question, do you think that that might be a key provision to look at in interpreting this?
Congress wrote what it wrote, and it referred us back to 523A. One of the decisions, Hawker Beechcraft, talks about looking at the punctuation, looking at the grammar of that situation. And when you're referring directly back to the biggest statute that deals with dischargeability, 523, it tells you that that provision applies to individuals. If Congress intended to be
they didn't
specific,
quite say, they didn't say refer to the provision. They talked about debts of the kind.
and those kinds.
So the question is the breadth of the term "of the kind."
And my reaction to that is you must look at the language, the clear language of 523, when you're trying to understand what the debts of a kind are, and debts of a kind that relate to individuals. And I don't think you go beyond that statutory clear interpretation, because otherwise you're going to throw away the preamble that makes it focus on individuals exclusively. Back to this structure, I was talking about the fact that it's not an absurd result. To the extent that a fraudster comes in, has a tax debt, has a willful and malicious injury, and it's a corporation, this still makes sense. Now, I would disagree, and there is no tax debt. The Cleary packaging case is really driven by Mr. Fasano's $4.7 million judgment. And we have to treat that in the Chapter 11. But what can be done in that instance? The IRS is not powerless, and sub 5 is not powerless. In the provisions of sub 5, you can remove the bad debtor for fraud, both pre-petition and post-petition, gross mismanagement. The sub 5 trustee can then kick out the debtor in possession. And if it's that bad, there are plenty of tools in the toolkit, both for aggrieved creditors and for tax debt, to resolve this issue. But if the confirmation completes and the debtor provides for a payment over 3 to 5 years, those golden handcuffs commit them to every penny of disposable income for the next 3 to 5 years. So it is not unjust that a corporation actually pays its debts rather than goes Chapter 7 and liquidates. And those individuals, I think it's important to think in the context, those individuals still remain liable if they file a fraudulent tax return, which is the example here under 1141 D6. Those individuals will still have a price to pay. They're not out of the woods just because their corporation is going to pay that tax debt. There may be criminal ramifications for a false tax return. They may be held 100% liable as a responsible party.
IRS is saying they don't want the debt discharged.
Well, they have other remedies, and that absolute denial is
So
not
if
just.
a bankruptcy court discharges the government's tax debt, you think the government can then collect it?
From the end, if there's what I'm saying is there's other avenues. It is not that egregious to the extent that there's a fraudulent tax return and somebody
You have a
signed
small
it.
corporation and they commit tax fraud, or they just whatever, and the government says they don't want that discharged. And you're saying that they can get that money elsewhere after it's been discharged?
They can, if there's another responsible party, yes.
Well, I'm talking about the debtor.
No, debtor is free and clear. After 5 years of paying every penny, this provision gives them a discharge. But it's also important to remember, if it's a consensual plan, the discharge is entered upon the confirmation order. It's by consent. If we use 1191B, which is a cram down provision, they don't get that discharge. That discharge only comes at the end once they've paid all of that net disposable income over 3 to 5 years. And that is a big distinction that hasn't been pointed out in the briefs. But in preparing for today, that is a major difference that does not make the result absurd or perverse. It actually makes tremendous sense. You have somebody who is locked in and must.
I would think it'd be just the opposite. That what's the reason for allowing a discharge on a cram down and not allowing it in a voluntary? In other words, plan. The question is, what's the whole reason for 523?
Well, the reason for the delayed discharge.
The 523. The reason for 523 is we don't want to give a discharge, a bankruptcy benefit to somebody who's committed a fraud.
That's true. And that principle resonates throughout both state law and bankruptcy law. Yeah. But there are exceptions. There's an exception in the Chapter 11. There's an exception in Sub 5. And to the extent that you do what you're told and you pay your net disposable income and you are working very closely with the Sub 5 trustee for the next 5 years, making sure you pay that, you're paying the price to get that discharge once you're finished. Only once you're finished. And if you don't finish, the discharge is not entered. So you've got to commit yourself under this Sub 5 structure for 3 to 5 years. And it's very compelling, and it encourages businesses.
Does your plan in this case call for the full payment of the $4.7 million judgment?
It does not. It provides what the statute provides.
I know, but you were just arguing that the rationale for this was that there would be a full payoff in 5 years and nobody would be hurt. But now you're saying in this case, the plan doesn't provide for a full payment of the 4.7 million.
What I'm saying is it provides for full payment of the net disposable income. So after the expenses
What
are
about
paid,
what happens to this debt, $4.7 million debt at the end of 5 years?
it receives every penny of net disposable income. It's better than a garnishment. It's better than an attachment. It is better than any of the state court collection remedies. You are handcuffed to a payment program that has to pay every penny. So the absolute priority rule that we talked about earlier, that doesn't matter because nothing goes to the owner. He gets a salary, he gets no distributions. He has to just commit himself to paying this off over the next 5 years. And that's not unreasonable.
He's discharged from a debt
That's huge.
that is large, and that is arising from tortious misconduct.
That is correct. It could be worse. And it's still,
It could be better, though.
and to the point, back to Judge King's question, why is this so important? Because if you don't allow some pressure relief valve, you're just going to close these businesses. You're not going to have reorganization. You're not going to save the small town businesses.
Has that been the experience with respect to farmers and fishermen?
You know, the farmers and fishermen, the Chapter 12 cases are.
My question is whether the experience is here that it's going to cause the loss of farms and fishermen. I would think just the opposite.
It does give an opportunity in Chapter 12, like Sub 5, to preserve those businesses. For the same reason, do we want to shut down family farmers because they had a bad crop? Do you want to shut down?
But yet, under farmers and fishermen, we don't let them discharge fraudulent debt.
I believe those cases are wrong. I do not agree with them. I do not believe with the Breezy Ridge decision, and I do not believe with the JBJ decision at all.
How long has Chapter 12 been in place?
Chapter 12, that's a good question, was in place 30 years ago, 33 years ago when I started. So I know that much.
You think these decisions based on 20, 30 years of experience, they're just wrong?
No, I think that the analysis engaged in by those judges in Georgia and Texas is not correct because of the debts of a kind language that we get hung up on.
Have any judges gone the other way, the way you'd like to go under Chapter 12?
I have found none under Chapter 12, but I've had two good decisions, and now the decision out of Idaho by Judge Hillen, who also found the same way as Judge Harner and Judge Ruark. So those cases, I think they recognize what the entire purpose was of the SBRA.
Has any other Court of Appeals addressed this issue, to your knowledge?
No, I checked this morning and there are no new cases. Nothing. This is the first case. I think it's a very important decision to make sure that, especially in difficult times, there are remedies that can be used. And the Chapter 11 discharge has been around forever, since the 1898 Act, when for the first time, America had a real national bankruptcy law that dealt with not just liquidations, but reorganization and the discharge, the forgiveness of debt, and allowing companies to continue in business because that American model allows us to keep going. And there's a reason why it's in the bankruptcy clause, Article 1, because bankruptcy laws are so critically important that our economy and the federalist system that they envisioned promotes those businesses and doesn't resort back to debtors' prisons and just straight liquidations, which puts no money generally back in the pocket of creditors. This provision is special, it's important, and I think it's successful because it pays money where no money otherwise would be paid. Your Honors, in the interest of allowing my brethren more time, I'm open to other questions. But
thank you, Mr. Brandon. Excuse me, Mr. Sweeney. I think the only other person on deck is Mr. Fasano. Is that right? Thank you.
Thank you.
Your Honor.
Your Honor, asked Mr. Sweeney, which statute should you look at first, 1192 or 523? And I think you have to look at section 1192 first, because that is the specific chapter specific, and it should govern over the general statute of 523, which applies throughout the bankruptcy code. But if you were to look at 523 first, you would see that it only by its terms applies to individuals. And then when you look at 1192 and you see the reference to 523, there would be no need for that reference if it only applied to individuals. The reason it would be there would be to make it to apply to corporations.
Well, just to play devil's advocate, what would be implied would be 1192 applies generally to corporations and individuals, because they're defined as debtors, except to the extent that individuals have incurred fraudulent debt. That would be the implied term in there.
But then you would have
That's
no
why I'd
reason.
say of the kind is probably a pretty important term to consider.
Right. And that's the of the kind language that's been held to apply to corporations in traditional Chapter 11 and in for corporate Chapter 12 cases. Chapter 12 is to answer Judge Motz's questions, Chapter 12 is the only chapter of the bankruptcy code that doesn't have an absolute priority rule, but which corporations can file. So that's why the Chapter 12 law is so important, is because that's the only chapter that has that statutory framework that this new subchapter is applying to small businesses. Mr. Sweeney talked about at great length the downside of holding these types of debt non-dischargeable, asking what his client could do. Well, there's a lot of things that his client could do if they're truly seeking to reorganize. One thing they could do is propose a Chapter 11 plan that pays more than 2.5% of our claim over 5 years. That might get them there. The other thing they could do is convert to a traditional Chapter 11. Subchapter 5 is purely voluntary, but if they convert to a traditional Chapter 11, they would have the traditional discharge under Section 1141, but they would have to subject their client to potential competing plans of reorganization filed by creditors, and they would have to subject their client to the absolute priority rule. They've chosen not to do that. Instead, they filed under Subchapter 5. They're not going to be able to confirm a consensual plan. And because they're not going to be able to, 1141D simply does not apply in this case. 1141D is excluded by operation of 1181C. We go to 1192, which takes the language of 1228 and which takes the language of 1141D6, which have been held to hold that fraud debts of corporations are non-dischargeable. For those reasons and the reasons in our brief, I believe the bankruptcy court should be reversed.
All right, thank you. All right, I thank counsel for their arguments. Our practice in the Fourth Circuit is to come down and shake your hands. This is began in the 1930s with Judge Parker. It's a sort of an iconic tradition, and we love it, and I think lawyers like it. We're still operating under protocols with the COVID, so we're going to pass at that this time. But I know we're going to see all of you back and shake your hand at that time. But thank you for your arguments, and we'll proceed on to the next case.
Thank you.
Thank you, Your Honor.
Yeah, I'm going to call this case again. I didn't realize counsel were out in the hall still. Sinai Hospital versus National Labor Relations Board. And I think first up will be Mr. Paltel, and we'll hear from you whenever you're ready.
Thank you, Your Honor.
question before the court today is whether or not individuals who are engaged to provide janitorial services at the Social Security Administration in Woodlawn, Maryland, maintain a primarily rehabilitative as opposed to industrial relationship with their employer, VSP. If, as VSP contends, it is primarily rehabilitative, the individuals are not employees under Section 2(3) of the National Labor Relations Act, and they cannot organize for purposes of collective bargaining. The Fourth Circuit has previously addressed this issue in 1998 in the Baltimore Goodwill case and found that individuals providing janitorial services at the same physical campus, the Social Security campus in Woodlawn, are not employees covered by the National Labor Relations Act. For many of the same reasons that the court relied upon in Baltimore Goodwill, we believe the same conclusion should be reached in the current matter.
But of course, the reasons are what's important because what we're reviewing are findings of fact, right?
That's correct. That's correct, Judge Motz. And this is, as we were discussing in the hallway, this is a very factually intensive case, a 1,200-page record. The legal standards are relatively straightforward. It is set forth most recently in the NLRB's Brevard Achievement Center decision, where the board set forth a multi-factor test to be used. But the question really is the same question that was presented to the Fourth Circuit back in 1998 in Baltimore Goodwill, whether or not it's primarily rehabilitative versus something which is typically industrial. So looking at the facts, we first have to look at the legal standard that is to be applied. And the question is whether or not the NLRB's decision is supported by substantial evidence in the record as a whole. In 1999, in the Sam's Club decision, the Fourth Circuit elaborated upon what it means to be supported by substantial evidence in the record as a whole. And the court explained that the board must take into account whatever in the record fairly detracts from the board's fact-finding, and explained further the board is not free to prescribe what inferences from the evidence it will accept and reject, but must draw all of those inferences that the evidence fairly demands. We believe that the board erred in this case because it failed to take into account the substantial evidence that detracts from its conclusion that the individuals are employees who are working in a typically industrial relationship. Applying the factors set forth in Brevard Achievement Center, I'll talk first about counseling, rehabilitation, and training.
We have a lot of facts in there, and I must say, if you undertake the task which you're trying to argue, it's going to be an uphill battle. The record has a lot of evidence in it, and for us to question the weight of the evidence the board took is a difficult task for an appellate court to second guess. But your argument seems to omit and leave out the whole Javits-Wagner Act program and the nature of the program and what Congress wanted in this program. And the idea that every one of these employees are under that program and are all, at least 75% of them, are disabled as defined by the Act, which has to be certified every year. And the question is, people under that Act, should they be subject to organization? And that Act is so non-economically oriented. It's all rehabilitative focused. There is regulation. I took a little look into this, and I didn't get a lot of help from your brief, but if you go through the regulations on the requirements, the checks, the different people that organize, the amount of pay they get, who sets the pay, it's a charitable organization here that's doing this. No court, until the Georgia court, no court had ruled that people under that program were subject to organization. And you yet start digging down into the weeds and talking about the facts. I think it's hard to overcome with it. I mean, the LRB had a lot of testimony. It's a big record and it goes different directions. But the bigger picture is that this is, by definition, a rehabilitative program of the disabled, and they have to be severely disabled. And those disabilities are defined. And the people on this list, some of them are mentally disabled, physically disabled. It's in the record. And that program seems to me the antithesis of an industrial organization where the employees are seeking economic benefit. These employees are not seeking economic benefit. They're trying to learn how to hold down jobs, to be placed, to have something constructive. They're all in janitorial positions, and none of these points are advanced. And I sort of asked the question, and I'm going to ask both sides, whether there's almost a categorical approach that we should not be subjecting these disabled people to union organization when they don't even perform in an economic sense. As a matter of fact, it's all an exception to economics. And the Brever decision focused on economic issues in collective bargaining, as distinct from the rehabilitative, which are not subject to collective bargaining. But you go ahead and present your argument, but I'm telling you where I personally find the issues more interesting is in the overall structure of the program, the purpose of the program, and its success in terms of the program. We have incidents where there are employees that stayed a long time, and some of them stayed a long time for a lot of different reasons. It doesn't show rehabilitation if they just stay there, but some of them can't get jobs. Some of them just quit. Some of them don't show up. Some are fired. But that doesn't go to the notion that they need representation to improve their economic condition. They need help in the rehabilitation, and that's what the Javits program does. And it's got programs and sub-programs. It's got monitoring. The employees can only work in a public place for the federal government. This is not the private industry of any kind. The conditions go on and on if you read in through the regulations. I'm a little surprised that the government doesn't coordinate with the other branches of its government which are promoting this program. This is a NLRB which is trying to promote representation, which is a terrific thing to promote, but it's for economic benefit. These people are getting very low incomes. They're specified by a rate schedule the government provides. The Social Security pays those rates. And VSP takes no extra money. They take just the amount paid to the employees. So there's no economic issue for VSP, which is a nonprofit. And so the question now is, what is the overall nature of these employees? Are they industrial employees or are they rehabilitative?
And Judge Niemeyer, we would agree that they are in a.
I would think you would.
Yes, that would be a shock if you had shock. But what is interesting is you didn't argue any of that.
Well, because the board has asserted jurisdiction in the past.
Brief that issue.
We did not delve into that in the brief because we did not believe we
What
would
authority do
prevail.
we have to decide on an issue that's not presented to us?
And so we did not believe as a matter of law that these individuals are categorically exempt from coverage by the National Labor Relations Act.
Categorical and the playing with the language. The question is, in your brief below to the board, you did talk about the program at some length.
Right.
And that to me was the most persuasive argument you made. When you're brief on appeal, you abandoned all that. I don't know if you abandoned it, but it's certainly not emphasized. You focus on whether the board had sufficient facts in the record to make the findings it did. And I'm going to say, you pick any fact in there and I'll bet you will find evidence to support it. Every fact that they found. It's the problem for me is that loses the forest for the trees. I mean, and the forest this is a rehabilitative program, not an economic program. Nobody is profiting on it. This program is the goodwill of Sinai Hospital in sponsoring these people and paying them. And they're trying to help out these 44 employees. And I don't see why it's useful to say that they're industrial employees, but not because of what you're arguing, but because of the whole structure of the whole program. And it's not that this is an exception to the program, because it's certified every single year. And there's investigations made, and the definition of disability is very severe. I mean, people with Down syndrome, other types of things, people do their work at their own pace. That was the testimony here. You're trying to help them come to work every day, have a job, create the dignity of humankind, and try to place them if we can.
That is, I mean, we agree, Your Honor. I mean, I think we view this the same, and perhaps we erred in not emphasizing this in our brief, but we viewed this as, because of the structure of the Javits-Wagner Act, by definition, the individuals, at least 75%, must be severely able. I mean, the language from the CFR is that they must be unable to engage in normal competitive employment. So that does obviously dramatically limit their abilities to work in a typically industrial relationship. And we believe there was literally hundreds of pages of testimony from...
If you're going to go all into that, you have to go into Source America, you have to go in niche. Source America is a national industries for severely handicapped that's sponsoring this. You have to go into niche, you have to go into the President's Committee, all these reviewing committees that determine the nature and structure of this program, which is designed completely and 100% to rehabilitate people who are disabled. And you know how they get into the system? From places like Chimes and disabled people in Baltimore City. They're trying to get these people off the streets and out of bad situations and rehabilitate them. Now, none of that is emphasized in your briefs. You talk about what an individual does on a day-to-day basis.
And Your Honor, again, we have to work with the record that we have. And
you don't have this. You have this record. They're all part of the program that was presented to the court below. I mean, the board. It's just that you chose to argue the substantial facts, which I think is, when we're reviewing an agency, I don't know where I'm going to go on this. My colleagues will probably kick me and say, the facts support this, and I'll say, okay.
Well, Your Honor, look, and I believe that in this case, we have overwhelming facts, even under a standard of whether it's supported by substantial weight. We have overwhelming facts to show that the NLRB erred here, and there's compelling evidence in the record showing that I see my time is up, Your Honor.
Okay. We'll hear from, who's next up deck? Mr. White? Are you number 2 in the batting order?
Yes, Your Honors.
Okay.
Thank you, Your Honor. May it please the court. Eric Whites on behalf of the National Labor Relations Board.
Mr. Whites, before you begin what you probably prepared, do you have any response to what Judge Niemeyer said?
Yes, Judge Motz. I was going to begin responding to, hopefully responding to Judge Niemeyer, your line of questioning. Of course.
Let me suggest to you, and this is no reason to command, you're welcome if you wish to remove your mask to talk. If you're uncomfortable with that, please don't do it.
No, I'm happy to do so. I didn't.
No, it's up to you.
Yeah. So to the agency's first response, which I think came up in some of the questioning, of course, would be that issue was not presented in this case and was not litigated. And so our position would be it's not properly before the court, specifically under.
But it was before the board.
Correct, Your Honor. But
the briefs extensively go into the nature of the program and the benefits but if you really get into the program, the deeper you get into it, the farthest issue from the considerations of the program are economics. The economics are basically donated money. What is the real guts of the issue is let's get some people better. Let's get them to learn how to work. Let's get them to feel good about a job. And they have these various programs. They have the President's Committee, Source America, and all these that have inputs and reviews. And then they have to work for the federal government. And in this case, I suppose a profit. I don't know if a profit company could supply it, but it's in this case, it's a nonprofit. They basically pay the employees, and the only thing they get back from Social Security Administration is the reimbursement for the pay. That's the nature of the contract. And so those facts, but not in that detail, but those facts were presented to the board, and there was a sort of background facts that introduced those facts to the board. But then the arguments were, as you made them before the board and as responded to, and you put in a good case. I mean, you put in a lot of facts in there. But
Thank you, Your Honor.
I wonder why you'd want these disabled persons who are trying to make it, want them to be organized. I mean, that's for what purpose? I guess you can, it provides a grievance procedure. It provides, I don't know if you can even improve their economic circumstance through collective bargaining. You might be able to, but I'm talking about legally, because their income is determined by a rate schedule.
Well, I think I have a substantive response to your questions, Your Honor, but just returning briefly to the procedural response, there was certainly some facts that this is a contract under the Javits Act and some of the details of that. However, what's I think very clear is that the employer was never challenging the board's established Brevard County standard and the established criteria for this exception. So the actual legal test that the board applies was not challenged. And even if it had been challenged, I would submit that this court has already affirmed it in the Baltimore Goodwill case, that you can have employees who are working under these types of contracts for government agencies who either can have the rights or can be excluded based on this established test. But turning to the more substantive,
holding in that goes the other way for you. The basic, that's an acknowledgement. Well, and I think it's a hard case to make. I tend to sound that this should be categorical, and I don't think any court has said that. But it seems to me, in the overall structure of the federal government, on the one side, you're promoting collective bargaining. On the other side, you're trying to get good employees. You're trying to develop people who can be employees. Right. But these people are at a stage where they haven't become employees yet in the labor sense. They're trying to be rehabilitated, and so I would think that an overall czar in the federal government would balance these two agencies. Say, well, we got this Javits program. Let's leave collective bargaining alone there until they become employees, and then let them bargain.
Yes, well, the first response would be returning just to Baltimore Goodwill. I think the court obviously disagreed and reversed the board there on the facts, but I think the court clearly affirmed the board's legal test for determining whether this exception should apply.
Well, that's the Brevard test, right?
Correct.
Yeah, I think it's the right test. I think it's absolutely right. My only question is, Brevard breaks it down between economic issues and rehabilitative issues. They use the word economic promotion, I think. And another one calls it industrial employee or whatever. But I think that's absolutely right, because the whole purpose of collective bargaining is an economic issue. It's to improve the terms and conditions in the workplace and provide grievances in this type of thing. But the question is, if you look at this program under Brevard, I have a hard time seeing how it satisfies the economic more than the rehabilitative, because I think the whole design of the program is to rehabilitate these people. And it's not always succeeding, which means there's working as severely disabled people working as janitors, and they're trying to get them to come to work every day and show up every day.
I do have a factual response. I mean, obviously, all of Your Honor's questions are well taken about the importance of this federal policy under the Javits Act. I would first,
that's the whole program for this group, right?
Certainly,
the SP is doing it under the Javits program as a charity type operation, and they're taking people out of the charities in Baltimore City who are severely disabled and who have trouble getting jobs, and they're picking those people up and paying them as employees and putting them in government locations.
Well, I think that's not exactly correct, Your Honor. I think it would be helpful to clarify why this case is different from, for example, Baltimore Goodwill or the Davis Memorial DC Circuit decision. Those cases Davis
Out in
Memorial.
Colorado. As a matter of fact, I only know of one that goes your way. All the rest of them go say that these people under the Javits program are not subject to collective bargaining.
Well, it's a small universe of cases in general.
I know.
But factually, so Davis Memorial, for example, I think was the type of program that Your Honor is talking about, where it was clearly both components of it, the actual skills rehabilitation component and the job site contract were an integrated whole in that case. So, for example, in Davis Memorial, when disabled individuals were initially referred to this program, they were initially at a job or a location where they were solely receiving rehabilitation and job skills training and mental health counseling and those sorts of things. And at that location, when their productivity hit a certain threshold, 75% of a non-disabled employee, they were automatically transferred to a job site where they continued to receive training. And if they had any issues there, they were automatically referred back to the rehabilitation facility. So it was an integrated continuum. And I think, as the DC Circuit held in that case, that is the sort of program that I think Your Honor is referring to, where the employer is solely attempting to rehabilitate employees.
Well, I didn't dig in the facts deliberately because I think you have a mighty powerful case on the facts that were found by the board. My comments go to the notion that while the facts on any given individual here may add up to this or that, the whole program was designed to rehabilitate. And the fact that every year the program is assessed and evaluated to make sure that that's what they're doing, serving the purposes of the program. And so while there's what you can have 25% non-disabled people, they make sure that they're 75% severely disabled and other factors, whatever the assessments are. And these are done by specialized agencies. So this is not just a normal employee-employee relationship. This is a program under the federal government, a welfare program helping people get better. And well, that's my general observation. And while their factual contradicts it, individual facts, as the board found.
I think, Your Honor, respectfully, there's significant programmatic facts in this case. And first, I just note, obviously, that is the purpose of some of these federal statutes. But I would push back a bit. I think it's actually a very complicated regime as to what funding is going where. And in this case, BSP has two separate and distinct programs. At certain points in the employer's brief, they attempt to merge them. But in fact, what the facts show is that when disabled individuals are referred to BSP through various governmental agencies with the sole goal of helping disabled individuals, they are sent to the entirely separate vocational skills program, which also receives federal funding under some combination of federal statutes.
But they're not the potential people here.
Correct, Your Honor. Those individuals are not at issue here. What actually happens is disabled individuals are referred to that program. They undergo weeks of training and have on-site mental health and other rehabilitative professionals. And here they've essentially graduated that program and have been placed at this job site. Some of the individuals who have gone through that program are placed at completely normal employers like McDonald's or Walmart. And some of them are placed at a contract that the employer also maintains, but treats them as employees.
That's good for them. That's terrific. I mean, that's succeeding. And maybe you go to McDonald's and organize the employees or authorize them to vote on the issue. But we're talking about a group that went out to Social Security, and I looked at as much as could be revealed about that group. And there's a bunch severely mentally disabled. There's a group severely physically disabled. I mean, and these are not one or two. It's out of the 47, there are large portions of each. And I'm sure we're not allowed to see all the medical stuff, but it impressed me that this program is such a beneficial program.
Well, absolutely, Your Honor. But I would note that the board in this case in no way is penalizing the employer or calling into question the excellent work that they do, and that, for example, Ms. White does at the
Now
job
they
site.
would have to negotiate with the union over matters which are really rehabilitative in nature. In other words, they have a whole program as to counseling, and they have 6 people that are attached to this group, and they have a specified program, the way you do it. They have charts as to how they work. They fire people who don't respond, which is one of the facts that was found that some people are.
And I think some of those points go to the actual facts of this case and the analysis the board did. And the board found, and we would submit substantial evidence supports these findings, that the actual rehabilitative aspect of this job site is very minimal. And as a sort of meta
then
point,
it doesn't qualify under the Javits Act. In other words, they are monitored every year for that basis.
well, my understanding, Your Honor, is that the employer self-certifies them. And again, I don't think all of the details of that complex statutory scheme were litigated. My understanding is that arguably the main thrust of that program is to provide employment opportunities for disabled individuals, which is why the main criteria is 75% need to be classified as severely disabled. But as sort of a meta response, Your Honor, and again, our main response would be it's not really properly at issue here, but I would respectfully push back, Your Honor, that I'm not aware of any indication in the Javits Act that Congress intended to deny disabled employees or disabled workers the rights that they're entitled to under federal law.
I agree with you. But I'm taking the Javits Act as where it is and all the supporting institutions that function under it. And they're all focused on identifying severely disabled persons and trying to help them get better in society. And they have a bunch of different rules, all kinds. I ended up getting an additional memorandum from one of my very fine law clerks about what does a program require, and it's quite amazing. I mean, it's regulation after regulation under the program. And so when you look at that, you say, how is this economically driven when every aspect of this program is intended to rehabilitate somebody? That's my fundamental question, and that takes the Brevard standard, which is between the economic and the thing. Anyway, right, I do understand. I don't want to impose some categorical notion on your argument on the facts, because you make a good argument on the facts.
But I would like to hear your argument with respect to the categorical approach.
Well,
I don't usually talk about it in civil cases, but go ahead.
Obviously the board,
Which you didn't brief and which was raised here.
correct. I mean, that would be our primary response.
I understand that. I do understand that. And that may be a winner.
Assuming that, there had been a challenge to the Brevard County test or Baltimore Goodwill, and that the actual board test was that issue, I think, returning to the response I was giving before, I'm not aware of any. And I see that my time's up. I can finish.
You can answer my
Please
question.
answer the question.
I'm not aware of any indication under the Javits Act or any other statute that Congress wanted to treat disabled workers who Congress wanted in the workplace treated with dignity and respect as workers, that they should be denied all of their rights under federal law. I mean, the implications of that would not only be.
I think that's too direct a conclusion. In other words, what I would insert there, you might agree, is that the Javits program is directed, it doesn't go to whether they can't be employees. It goes to taking disabled employees and trying to habilitate them. And then the question now, you have to now move to Brevard and say, are these employees, when they're in the program, are they being treated for rehabilitative purposes, or are they industrial workers? And which Brevard makes clear means economically motivated.
Right. And I guess the very brief answer to that then, Your Honor, would be that, we would submit that rather than having a categorical rule, the board is well placed to look at the, setting aside what a given employer is supposed to be doing or what the regulations require under the Javits Act. The ultimate inquiry, this is a very fact-specific case-by-case analysis, is what is going on at this workplace. And here the board developed a very extensive factual record, and we would submit correctly found and is supported by the evidence that there's very minimal rehabilitation going on at the Social Security job site. There's only one counselor who's there part-time. She's not a trained mental health professional or rehabilitative professional. She's in the employer's own terminology, an ad hoc and supplemental services case manager who certainly does admirable work and helps these individuals. But I think in this case, there's very minimal evidence that there's any actual rehabilitation going on to these individuals who, for all reasons are treated as employees, are subject to discipline, are regularly terminated, are required to do the same work as non-disabled individuals who receive the same pay, health insurance, and benefits, and many of whom treat this as their career and work here for many years. And so rather than having a categorical approach based on what the regulations of the Javits Act and related statutes require, we would submit it's reasonable to have a fact-specific inquiry, which is what the Brevard County test is, and to develop a factual record of what's really going on at a particular workplace. And at this particular workplace, we would submit there's very minimal rehabilitation going on. And for that reason, we would submit that the board correctly found that this is not primarily rehabilitative under the board created non-statutory exclusion to the definition of employee.
All right, thank you.
Thank you.
Who's up next?
I believe it may be me, Your Honor.
Okay, it is you. I see. Ms. McKaiser.
Yes. Good morning. May it please the court. My name is Ashley McKaiser. I am counsel for the union intervener in this case. And the reason that the union has intervened is to defend the collective bargaining rights of the individuals who are working for VSP at the SSA PEB site. And these individuals have elected the union by an overwhelming majority to represent them in bargaining with the employer over their terms and conditions of employment. Yet, if you look through the record at nearly every stage of this case, the employer has made efforts to prohibit these individuals from exercising their statutorily guaranteed Section 7 rights. And I kind of want to address Judge Niemeyer, your concern here, and jump off what NLRB's counsel, Mr. White, said, is that I think it's clear from the record that once these individuals are placed at VSP's site, VSP has no concern with fostering a rehabilitative relationship with the disabled janitors working at that site. And I think it's clear that VSP's motivation in this case is ultimately to prohibit all individuals from organizing, regardless of their disability status. And I think this is clear when you look at the record in this case. At the first day of hearing, the employer took the position that disabled and non-disabled individuals are treated differently at its site. When you go through that factual record, to VSP's surprise, turns out that all of these individuals are treated exactly the same. VSP stipulated at the beginning of the first day of hearing that
there's probably facts to support it, but there was also quite a bit of testimony that the counselors, the 6 of them that were assigned, one part-time, I think, on the site,
yes,
were assigned to respond and counsel the disabled. And when asked whether they would counsel a person who was not disabled, they said they wouldn't turn them away, but that was not their purpose. And they devoted most of their attention to the disabled. That was I forgot the woman's name, but the main head of the
director, I believe it was Lisa Mules. Point taken, Your Honor. But I do want to highlight that at the beginning of the hearing, the employer took the position that in a unit comprised of non-disabled individuals would be an appropriate unit. And after the first day of hearing, the employer changed its position. It took the position that both the non-disabled and disabled individuals would be an inappropriate unit. And its primary argument in taking this position is that a unit comprised of solely non-disabled individuals would be inappropriate because they have a community of interest with the disabled employees at the site. Now, in taking this position, the employer implicitly conceded that these group of workers do not have distinct terms and conditions of employment as compared to the disabled individuals working at the site, which is one of the factors used in the Brevard analysis. And I think all that the employer has proven, again, is that there's virtually no distinction between the working conditions imposed upon these two groups of employees. The only objective difference is their disability status. And under the NLRA, by its terms, the NLRA does not exclude disabled individuals from being covered by the Act. Again, the test is there a rehabilitative relationship here? Are we doing things at this contract site to ensure that disabled individuals can enter into the workforce as intended under JWAD? And obviously, it's the union's position that no, it has not fostered that type of relationship with these individuals here. And I think that's plain, and I won't go into the 1,200-page record. When you look at the facts on the whole, that the employer is not primarily concerned with fostering a rehabilitative relationship with these individuals.
All right.
Thank you.
Thank you. Right. All right. I think Mr. Peltel, you're back up, right?
Correct, Your Honor. Thank you.
Yeah.
Your Honor, first I will note, although it certainly was not our main focus, we did raise at page 12 of our brief the fact that the individuals are referred to VSP from DOORS or the Veterans Administration or similar entities and are covered by JWA, the Javits-Wagner O'Day Act. So we have raised the issue as kind of the factual background to show, by definition, anybody who is one of those 35 disabled persons at the site must be severely disabled. So we did raise the issue at page 12 of the brief. But I also want to just argue with my opposing counsel, which I suppose is my job, to highlight that there really is quite a bit in the record that supports the fact it's a rehabilitative relationship. We have, first off,
let me ask you this. There's quite a bit of evidence that supports that, and there's quite a bit of evidence that doesn't support that. What's our role?
Well, I believe that the board improperly ignored the greater weight of the evidence, really, which is evidence that shows it is not an industrial relationship. If you look at the record as a whole.
Standard of review?
Pardon me?
Is that our standard of review?
Your standard of review goes back to whether or not, when looking at the record as a whole, it is supported by substantial evidence. And again, to go back to the Sam's Club.
Supported by substantial evidence?
And the substantial evidence in the record as a whole, and again, taking into account.
You said that's substantial evidence is simply more than a scintilla.
It is more than a scintilla, but I believe where the board erred in this case.
Tough standard.
Pardon me?
That's a tough standard.
It is. I recognize.
While you're in your shoes.
It is an uphill, but this court has previously in Baltimore Goodwill found there to be sufficient omissions, essentially. And look at Baltimore Goodwill. In Baltimore Goodwill, you had a very factually analogous situation to the extent we can deduce what the record showed. There in Baltimore Goodwill, there were two union witnesses or board witnesses who testified that they had not received counseling. And the board relied upon that in finding that the individuals were covered by Section 2.3 of the Act. When it got before your predecessors at this level, the Fourth Circuit looked at the evidence the board had not relied upon, which showed that, in fact, these individuals had been counseled, and used that in part to reverse.
What year was that case?
1998. And I believe we have a similar situation here. If you look at the evidence.
Some of us were not predecessors. Right?
I did check on my drive down this morning to see if you were on the pen.
Were we all on the court then?
I have to say, I pulled over at a rest stop on I-64 to make sure that none of you were on the panel back in 1998.
That's right.
But they may have been your colleagues. But in the current case, we have the evidence relied upon the board is really very slim. You have two witnesses, one of whom, Mr. Parker, is disabled. The other is not disabled. That would be Ms. Tyler. Mr. Parker
is the only one who testified he was disciplined and did not get any kind of counseling. But when you look at what he actually testified to, he said, I was asked to go see Ms. White. And I was for the opportunity to have her give me rehabilitative counseling. I declined to do so.
So the only factor that you want to talk about is counseling. And I think you're right. The evidence on counseling is most favorable to you of all of these other factors. But if you look at any of the other, and I'm not sure that you even win on counseling, but if you look at all of the other factors, for example, the terms and conditions of employment, or the imposition of production standards, or the tenure of employment, or the disciplinary procedures, they all go against you.
I beg to differ, Judge Motz. I think if you look
I know you differ, but there are substantial findings in there, and all we need is a scintilla. So maybe you want to talk about them instead of the one that is most helpful to you.
So let's look at discipline. So Ms. White's testimony in the case of discipline was that there was an individual in the probationary period who was counseled and coached 8, 9, 10 times. That's a quote. Before the individual was terminated, whereas others are terminated after only 1 or 2 latenesses. And that's exactly what the board relied upon in North Georgia, when the board found in the North Georgia decision that the evidence showed it weighed in favor. Although ultimately it ruled against the employer, it found on the evidence, on the issue of discipline, the evidence weighed in favor of a rehabilitative relationship, because in North Georgia, an individual received progressive discipline 6 times for failing to perform his job duties versus only 3 times for non-disabled.
More disabled janitors were discharged than successfully moved on to outside employment, right?
Over a 5-year period, that is correct. That's a correct thing. But
I mean, I think we've all tried to tell you. First of all, re-arguing the facts is not helpful in any case, really, because we take the facts as they're found. And if there's substantial evidence supporting them, sort of across the board in cases, we affirm. So I don't know that it's helpful, and I particularly don't think it's helpful in this case, because there are lots of facts and lots of findings against you.
And I would agree there are lots of findings against us, but I do not believe that when you delve into the 1,200-page record, Your Honor, that those findings are supported by the testimony of either the union witnesses or the employer's witnesses. And that's in large part where we believe the board erred. And we believe that's similar to what happened in both Davis and in Baltimore Goodwill, where the circuit court reversed the finding of the lower court. So I know I'm almost out of time. I'm not going to rehash the facts. I think I know where you stand on that, but I do believe there is enough evidence that was ignored by the board to show that the board ignored its statutory duty to review the record as a whole and also consider the evidence which detracts from the board's finding as well as that which supports it. Thank you.
All right, thank you, Mr. Peltel. All right, I appreciate counsel's arguments. It is our custom and practice to come down and shake your hands. And we're not going to give up that practice. I think it's been around for a while, and it perhaps defines our court in some respect. But under the existing protocols, we're still observing that, and our masking as you're accommodating us on. So we very much appreciate having your arguments. You have to accept our greetings at this point as our shaking of hands. And when you come back again at a later time, we'll shake your hands. You'll all be before us again, I'm sure. But we enjoyed your arguments. You did a good job, and we'll adjourn court till this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.